Lordship, Lordship, may I have one apparate side mentioning, Lordship?
No, when I take a pipe.
Lordship.
At 2 p.m., please come. No, not 2, 3 p.m. today.
My Lord.
Please.
Yes.
May it please your Lordship.
But may I make one request? I believe he will take his time today, but in case he finishes, if I may be excused.
Sure.
Okay.
Well, for the reasons he has given, I said I consent to it. You want to it's between you?
No, this is just being in a lazy mood. I want to run away from court and go outside Calcutta.
It's good that Mr. Mitra permitted that.
But,
Because it's his hometown, it's common home.
Yes. So, okay, তোমার briefটা দাও.
আসেন
Lord will kindly give me one.
yes, please.
তোমার এসে
Kindly give me one second.
খুঁজে বার করে দেবে
না কিছু না
হ্যাঁ মনে হয়
মনে হয়
তুই যা
এখন যাচ্ছি এটার জন্য তো প্রত্যেকে পড়েছে ট্রেনের টিকিট পাচ্ছি
you're not entitled to fees.
Well, 2 dates I would give your Lordship, my Lord. Perhaps your Lordship can make a note of it. Yes. My Lord. On 8th October 2021. Yes. My Lord, my client, that is the petitioner, my Lord, was put into corporate insolvency resolution process. And my Lord, under my Lord, section 227, the Reserve Bank of India initiated that. And my Lord, the moratorium was declared on 8th October 2021. And my Lord, the board was superseded. My Lord, this continued until 11th August 2023, when the resolution plan was approved and the implementation and monitoring committee was appointed. Thereafter, the monitoring committee handed over the management to the new management of the petition account.
26th of February 2024.
That is on 26th of February 2024. So, my Lord, from 2021 to 2024, the petitioner before your Lordship was in a state of flux. And my Lord, the new management came in, and thereafter, my Lord, the proceedings went in. My Lord, now, keeping this in mind, I will request your Lordship, my Lord, to look into the petition, the paragraph. Kindly come to paragraph, page 260. This is the affidavit of reply filed by the respondent before NCLT, wherefrom we came to know of this award. Lordship will be pleased to come to page subparagraph. This is the affidavit in reply, which starts at page 262. It starts, kindly, my Lord, come to subparagraph K at page 8. When the respondent had been contesting the claim of the petitioner, my Lord, this is what they said, subparagraph K. With regard to agreement number 130853, these are the two, my Lord, contracts where one is 130853 and the other is 138524. Now, this is what regarding 130853, and this is what they said. Subparagraph III, bottom of page 268. Yes. Thereafter, the financial creditor invoked the arbitration clause as contained in the loan agreement, and the parties jointly nominated so and so as the sole arbitrator. Then on 17th of September 2020, learned sole arbitrator given a past and arbitral award, which inter alia is as follows. And that then, my lord, it sort of quotes from that. And then subparagraph 5 at page 271. From the aforesaid award dated 17 September 2020, it is evident that the claims by the financial creditor under the aforesaid agreement were disallowed on the grounds mentioned therein, and that even though the financial creditor has sanctioned rupees 1,89 lakhs towards agreement number so and so, it had disbursed only a sum of rupees so and so, and corporate debtor, etc. A copy of the arbitral award dated 17 September is annexed herewith and marked annexure R9. This, your lordship, has been pleased to see at page 291 to 300. Now, my lord, then kindly come to subparagraph L on the very same page, 271 bottom. With regard to agreement number 138524, my lord, is the second my lord, award, which is sought to be challenged before lordship. Dated 15 July, then, my lord, the narration is there. And then it says at in subparagraph, again, it is saying in subparagraph I at page 272, the invocation of the arbitration clause and the award. And it says in subparagraph 5 at page 274, from the aforesaid award dated so and so, it is evident that the claims of by the financial creditor under the aforesaid agreement were disallowed and the ground mentioned therein so and so. The said purported claim made by the financial creditor under the said agreement is not maintainable, since such claim as aforesaid has already been adjudged. So after we came to know of it, my lord, we made this application. My lord, kindly see this particular reply is affirmed on 26th of January 2024. And my lord, we made this application before your lordship in the month of May 2024. And my lord, calculated from that, I have calculated it is within 90 days from that. But then again, my lord, I'm just wondering that if my contention is that this award does not exist at all, to what extent this period of limitation will be applicable? This is, my lord, something I was just toying with the idea, because I feel, my lord, that the period of limitation will, because limitation has been mentioned, my lord, over and over again in various parts of the opposition and in the supplementary affidavit, that the claim is barred by limitation. But, my lord, I think, my lord, this is not a, this is a contention without any substance, for the simple reason that if your lordship looks into the Arbitration Act,
in the strictest sense, limitation has not yet begun.
my lord,
In the strictest sense, limitation has not yet begun.
yes, quite.
You had a cause of action and you took out the section.
Yes, because, my lord, I feel, my lord,
no service of the
looking, I don't know whether I'm right or wrong. I feel, my lord, the limitation will start running from the date when, my lord, the arbitrators have served the copy of the award. The original award, my lord, on the party.
which you say was never served.
Yes, it was never served. Therefore, my lord, I think the, yes. Well, 19th April 2024, the petitioner filed this application. My lord, if your lordship, my lord, kindly take this. The reply was filed on 26 January 2024, and we filed an application on the 19th April 2024. So, in any event, it is within that time mentioned, Amakat Arbitration Act. My lord, kindly see, kindly look at first.
Ultimately filed on 20th.
Yeah.
It was affirmed on 19th apparently, because the date in the computer sheet is 20th. Anyway, all the same.
Your lordship, kindly see, my lord, section 34.
Yes.
Subsection 3. An application for setting aside may not be made after 3 months have elapsed from the date on which the party making that application had received the arbitral award, or if a request has been made under section 33, I am not troubling your lordship from the date on which the request has been made. had received the arbitral award. Now kindly come to section 31.
This has been interpreted as
Section 31, subsection 1. Form and contents of arbitral award. An arbitral award shall be made in writing and shall be signed by the members of the arbitral tribunal. Therefore, the signature of the arbitral tribunal is required for the purpose of completing an award.
And 34.3 does not say copy of the award.
No,
It says receive the arbitral.
And then, my lord, kindly come to subsection 5.
Yes.
After the arbitral award is made, a signed copy shall be delivered to each party. This is exactly what your lordship is saying. It is not a copy of the award. It is a signed copy shall be delivered to each of the party. And then we should read, my lord, section 34, subsection 3
In the light of 31.
light of
Yes.
My lord, this is my submission to your lordship on this, on the purely on the case of on the basis of interpretation. My lord, your lordship, that I do not know whether your lordship it's necessary to cite judgment. But in this case, I will just request your lordship to look one paragraph from the judgment reported in 2005 4th Supreme Court cases 239.
Judgments গুলো কোথায় দিস সাইড করেছে?
it has been already.
এটা দেখো তো এটা রয়েছে কি ওর সঙ্গে?
It has to be there.
If it is not there, then my lord, I shall hand up to your lordship a copy.
না এখানে নেই। তোমার অন্য ফাইলে আছে নিশ্চয়ই আছে।
না না পার করা
জাজমেন্টসের ফাইলগুলো থাকবে।
দেখুন আর
ওটা কি ওই ইয়ের তলায় একটা ফোল্ডার রয়েছে সাদা?
ফোল্ডারে অনেকগুলো
এই যে ওর তলায় একটা ফোল্ডার রয়েছে সাদা ফোল্ডার। তো অন্যটা তো দেখো না দিয়েছেন কিনা, যে কোনো একটা দিয়ে থাকলেই তো হবে।
ওরাও দিচ্ছে
5 and 6 একসঙ্গে হচ্ছে না?
My lord, may I hand up to you?
না, আমরা দিয়ে দিচ্ছি। তুমি এটা দিচ্ছ তো?
হ্যাঁ,
হ্যাঁ।
এটাই।
কি করে কি?
Both side will be easier, but the volume will be less. Yes.
Lord, kindly come to paragraph 6. This is a 3 judges bench Supreme Court.
Yes.
The judgment has been delivered by the youngest of the lot, Justice Navlikar. Lord, you will please to come to para 6.
Yes.
Form and contents of the arbitral award are provided by section 31 of the Act. The arbitral award drawn up in the manner prescribed by section 31 of the Act has to be signed and dated. According to the subsection 5, after the arbitral award is made, a signed copy shall be delivered to each party. The term party is defined by clause H of section 2 of the Act as meaning a party to an arbitration agreement. The definition is to be read as given unless the context otherwise requires. Under subsection 3 of section 34, the limitation of 3 months commences from the date on which the party making the application had received the arbitral award. We have to see what is the meaning to be
That the
assigned.
pivot is on the party.
Yes.
The department receipt.
Yes. The party making the we have to see what is so and so, and the party making the application was setting the award in the context of a state department government. Then, my lord, kindly come to paragraph 8. Here, my lord, with regard to the railways, the different departments and, my lord, the workload, etc., had been considered. I am not troubling your lordship. Paragraph 8. The delivery of an arbitral award under subsection 5 of section 31 is not a matter of mere formality. It is a matter of substance. It is only after the stage under section 31 has passed that the stage of termination of the arbitral proceedings within the meaning of section 32 of the Act arises. The delivery of the arbitral award to the party to be effective has to be received by the party. This delivery by the arbitral tribunal and receipt by the party of the award sets in motion several periods of limitation, such as an application for correction and interpretation of the award within 30 days after section 33(1), an application for making an additional award under section 33(4), and an application for setting aside the award under section 34(3) and so on. As this delivery of the copy of the award has the effect of conferring certain rights on the party as also bringing to an end the right to exercise those rights on expiry of the prescribed period of limitation, which would be calculated from that date, the delivery of the copy of the award by the tribunal and the receipt thereof by each party. Well, let kindly see that the delivery of the copy of the award by the tribunal and the receipt thereof by each party constitutes an important stage in the arbitral proceedings. So, my lord, I am putting two and two together. I say read all these provisions together. It gives the impression, and my lord, I respectfully submit to your lordship that should be the correct interpretation, that it is the award which is to be given by the arbitral tribunal in terms of section 31(5). Then section 34(3) comes into operation, and then, my lord, the limitation period. Well, in the facts of this peculiar case, my lord, I submit to your lordship, say, is there any award? Ultimately, my lord, the question that will arise is this: is there an award? I am not going into the issue of fraud, misrepresentation, etc., etc. I am saying that if there is an award, first of all, there has to be a proceeding. In the proceeding, it has to be shown that the two parties have been given notice and they have participated. Now, if there is no, there are sufficient evidence on record which dispels this kind of an impression, then, my lord, the question arises, what is being sought to be implemented as an award is not an award at all. My lord, I shall now take your lordship. I just wanted to, in passing, I just wanted to mention this before your lordship, because this is one of the points which has been raised. Now, my lord, I take your lordship into the merits of this controversy.
Regarding the application also, Mr. Mitra, probably we are hearing you whether this application, these documents should be permitted at this stage to be brought in. But they want to bring in certain documents probably by
yes, of
this
course.
day.
The documents have been pleaded, my lord. I tell you, lordship, my lord, petition, there are certain documents pleaded. Then, my lord, in the opposition, there have been some controversy on that. Then, my lord, we filed a supplementary affidavit. In fact, my lord, supplementary affidavit to the petition had been, my lord, responded to by the respondent by their affidavit in opposition. It was filed before the opposition was filed. Thereafter, my lord, during the pendency of the proceedings, my lord, there are certain new documents were discovered by the respondent. And they, my lord, made an application. First is by way of a supplementary affidavit.
Yes.
Your lordship was pleased to say that, no, I won't accept this supplementary affidavit when 2 days of argument had already been made. So they made a formal application for additional evidence. And that application, my lord, I said that since they are want to rely upon that, I did not contest it seriously. So, my lord, that application has gone in with certain. So, my lord, I will request your lordship, my lord, since all these things have come on record now, I am, my lord, emboldened to make my submissions on this.
এইটা দেখিয়েছিলাম ওই on the receipt of the award.
এটাও দেখো, my lord,
এটা নেই, এটা আছে।
এটা কি জজ সাহেবকে কপি দেওয়া আছে?
হ্যাঁ,
What is the citation, please tell us?
আরেকটা ছিল।
My lord, there is the one citation I have given to
No,
you,
that you have given the other one.
and the other one, my
So
lord,
what there?
is Dakshin Haryana
Dakshin Haryana is there.
2021-7.
Yes, that is there. Lord Atkins judgment is there. Narayan Chettiar, Privy Council judge. No, that is
And there's
by them.
On fraud and on this.
Right. So your judgments is to Haryana is there. Yes.
Yes,
Dakshin Haryana is there.
yeah,
That is
page
also
669. Say page 669, paragraph 25. The same thing has been said again.
26.
No, 25 টা কি দেখা, তারপর 26, 25 এর আগে 26 আগে 25 আসে না? Lord, you will please to come to para 25.
Yes.
Section 31, the Malad subsection 1, subsection 5 have been quoted there. Then para 26. 31(1) is couched in mandatory terms and provides that an arbitral award shall be made in writing and signed by all members of the arbitral tribunal. If the arbitral tribunal comprises of more than one arbitrator, the award is made when the arbitrator acting together finally express their decision in writing and is authenticated by their signature. An award takes legal effect only after it is signed by the arbitrator. The same thing has been said in treaty, which gives it an authentication. There can be no finality in the award except after it is signed. Since signing of the award gives the legal effect, signing of the award gives legal effect and validity to it. The making of and delivery of the award are different stages of an arbitration proceeding. An award is made when it is authenticated by the person who makes it. The statute makes it obligatory for each of the members of the tribunal to sign the award, to make it a valid award. The usage of the term shall makes it mandatory requirement. It is not merely a ministerial act or an empty formality which can be dispensed with. Then subsection 1 of section 31, read with subsection 4, makes it clear that the act contemplates a single date on which the arbitral award is passed. That is the date on which the signed copy of the award is delivered to the parties. Section 31(5) enjoins upon the arbitrator tribunal to provide the signed copy of the arbitral award to the parties. The receipt of signed copy of the award is the date from which the period of limitation for filing objection under section 4 would commence. This would be evident from the language of subsection 3 of section 34, which is then it has been quoted. Then para 28 in the
No,
Indian
36. Straight. 30,
36
36 and 45. Note 36 and 45.
36 আর 45
মানে প্যারা 36 আর
না
45
36 এর আগে তো 28 আসে না
ও আচ্ছা তুই পড়তাম
Your Lordship will kind come to
Tekotrichi has been
Tekotrichi
recited,
has been considered.
and that has been considered in another that has also
Yes. Then, my Lord, para 29, 30, different
similar.
provisions have been considered. Then, my Lord, kindly para 36.
34 may also be relevant.
Para 34. There is only one date recognized by law, the date on which a signed copy of the final award is received by the party, from which the period of limitation for filing objection would start. There can be no finality of the award except after it is signed, because signing of the award gives legal effect and finality to the award. And therefore, my Lord, this is the date on which it is signed, a copy of the final received by the parties. From that date, my Lord,
Yes.
the limitation will start. In other words, my Lord, what is being said here is this, that informally, if one party hands over a copy of the award to the other party is not obliged to, my Lord, treat it as an award which is in terms of section 31, subsection 5. So, my Lord, this is what it is. Section 36 summarizes this. I'm not going to trouble
Yes,
your
yes,
Lordship.
yes.
This is what this judgment.
না না 36 আর
ঠিক আছে 36 টা বলেছেন জজ সাহেবকে বলেছেন your Lordship will kindly look into it.
36 and 45
And 45, the 45 এ কি আছে এই provision to the এই আর কি
45 gives the in that fact,
This is a
fact of that case.
fact of that case. My point is very simple. Section 31 read with section 34 makes it very clear that it is the arbitrator's award which has to reach the party to enable, my Lord, the court to proceed on the basis that the time has started running from that day. So until that happens, my Lord, it is not the award is the proceedings are not complete. The proceedings come to an end only at that time. So, my Lord, this happened, my Lord. They first of all said that in the affidavit reply for the first time they said so. We came to know from this, and therefore, my Lord, and then, my Lord, immediately thereafter we moved this court for, my Lord, setting aside of this award. Now here I will submit to your Lordship, my Lord. This brings me to the last point on this, and this I shall take some time on this. Your Lordship now will have to consider as to whose version which has been put forward before Lordship is correct. According to them, we had knowledge of the award from the beginning, and therefore, and we allowed it to continue. I mean, we allowed the thing to, so to say, the award to remain on record. So today we are not entitled to come before the court and say that there has been no award. Now, to that, my submission is this: look at the surrounding circumstances on the basis of the documents which have been disclosed by the respective parties. Question is, does your lordship come to the conclusion on the basis of these documents that there was actually an award at that point of time, notwithstanding what is being contended by the respondent or what is being contended by the petitioner? Which version is correct? My lord, I will request your lordship, my lord. Here, there is one point I must also, meet that point. They are saying that, look, there is no dispute on one thing, that an application was made under Section 9 for the purpose of obtaining interim relief. Therefore, that was preceded by a letter of the advocate of the petitioner before, my lord, the initiation of these proceedings. And admittedly, the proceedings took place, participated by both parties. And ultimately, my lord, Section 9 application was withdrawn. Now, the inference that is sought to be drawn by the respondent from that is that, look, why is it that it should be withdrawn? That is because you wanted to have a receiver on the machine, which was the subject matter of the dispute. The machine was to be handed over or by law to be taken possession of by the special officer or the receiver. But you did not pursue it. So there must be the settlement of the claim. Maybe there is maybe some substance in that. I am not going to put my case higher than what it is. It's possible that that is so. But then what happened? If Section 9 application was, according to you, was disposed of on the basis of a sort of settlement between the parties, and the claim came to be satisfied there, then what was the necessity for going to arbitration in the first place? Number one. After 1 year. And that is also after 1 year. Secondly, the invocation of the arbitration is, my lord, shrouded in mystery. Two different versions are being said. One is by the respondent and the other is by the learned arbitrator. Now, there is a discrepancy in that. And along with that, my lord, I would request your lordship look into the contemporaneous documents which were exchanged between the parties. If a person gets an award which completely satisfied the claim of the petitioner, then when such claim is made subsequently by the petitioner, the first thing it is expected that the respondent would come forward with, that, look, there is an award. What are you talking? If that is not there, that is absent, then, my lord, the entire issue of arbitration becomes a suspect. And this is my respectful submission before lordship. অ্যাওয়ার্ডটা দেখিয়েছি, হ্যাঁ পুরোটা পড়েছি, হ্যাঁ। So I have shown your lordship the award. Now, my lord, kindly take certain documents, your lordship will be pleased to see. My petition. I shall just go through some of the documents in the petition, and, my lord, the documents which have been disclosed by their, in order to counter my submissions, the documents they have disclosed in their opposition and supplementary affidavit. Lordship will please to come to
Supplementary affidavit? No, supplementary we did not take.
the first. Kindly come to the petition.
My lord, they filed an
There'll be
application.
this section 34, opposition reply, and their application. These are the documents.
Yes.
Yes.
And the supplementary affidavit,
Did not take. I did not.
no, but they annexed it in the
application.
but they don't want it to be a part of those documents to be part
We'll
of.
stand up when this bell ends at 11. We have to stand up, Gandhiji.
Yes.
When this bell ends at 11, so we have some time. And then for 2 minutes.
Yeah, but there's supposed to be some kind of a
Siren.
Siren.
Siren nowadays probably doesn't happen.
Oh, I
We are not sure. This bell will end, then we'll stand up.
Oh.
10 seconds.
Yes, we were notified. For every time we forget, that's why the judges were notified. This will end, then the silence starts.
Lordship.
Yes.
Well, I don't know whether your lordship takes the statesman. There is a nice article which has come out today. The relevance of Gandhiji in modern world.
Statesman nowadays, I've stopped for some time because
Oh, I see. Statesman.
after Mr. Irani deteriorated,
Well,
then
statesman, my lord, is no longer
for a few, from a few years
very
back,
few
I
people take it. Well, I still adhere to the
have that convention.
When I read that there's a nice article on the
You
relevance
can give
of
us that,
Gandhiji,
give me that date, Mr. Mitra. I can follow in the on the internet.
lordship.
The date of that publication. When yesterday,
Today.
Thank
Today,
Try to
in the center spread, my lord, there is an article by.
Thank you very much. I'll definitely.
In today's world, your lordship sees Gandhi has become totally irrelevant.
Mahatma
With-
Gandhi.
Mahatma Gandhi. Yes, I am not talking of any. When I talk of Gandhi, my lord, there is only one Gandhi I think of.
Yes.
I don't think of any other. Only in movies. Well, let kindly come to page 244 of the petition,
Of their petition.
of our petition. This is in, my lord, in 529, 529 petition.
এটা আরো ভলিউম আছে? এটা কি এরই ভলিউম? এটা জি এর ভলিউম নয়। জি এর ভলিউম তোমার কাছে আছে? ঠিক আছে, ঠিক আছে, ঠিক আছে। No,
but
no,
this is
sorry, 200 and Mr. Mitra, sorry, 200?
page 244.
200, yes, yes.
Well, insofar as pleadings is concerned, our petition, our supplementary affidavit, their opposition, then, my lord, their supplementary affidavit, which was not accepted, but, my lord, then they made the application for additional evidence. With that, my lord, supplementary affidavit has been annexed, and, my lord, our reply to that. So, my lord, page 244.
Yes.
This is dated 30th January 2023. The authorized signatory is writing to, my lord, the Road Wings International. Third paragraph at page 244. Now, upon assessment of your aforesaid account, it has been observed that your accounts are default, and in spite of several requests made by us, you have deliberately failed and neglected to discharge your liability as agreed upon under the aforesaid agreement. As a result of such default, a sum of rupees 11 crores and odd annexure A. And then, my lord, we also put the company on notice that we propose, last paragraph on that page, to file an application under the Insolvency and Bankruptcy Code. Please do note that under the Insolvency and Bankruptcy Code, a notice of demand is not prerequisite. Then, my lord, the last sentence at page 245, we are again threatening them that we shall proceed before the NCLT. And, my lord, kindly come to page 246. This is an annexure to the letter, annexure A. Here, items number 5 and 6.
Yes.
In the agreement number, 5 and 6 are the 529 and 530. These are. And at that point of time, your lordship has been pleased to note it was under the administrator. So, my lord, as authorized signatory has written. My lord, there was no reply to this. Then, my lord, at page 247, the advocate on record has come into the picture, 30th August 2023, another notice of demand. Referring to the notice of demand dated 30th January, there, my lord, the amount has been claimed. This was also received by them. There is no dispute with regard to that. Kindly see the reply at page 250. It is dated 4th September 2023 by Road Wings, addressed to, my lord, the advocate. Your client Sri Equipment. We are in receipt of your letter under so and so. Together with further interest accrued thereon on behalf of your above client. In this connection, we deny any liability as sought to be slapped on us by your client in terms of the letter under reference. Our duly audited accounts show that all liabilities have been paid in full, and nothing is left to be paid towards any of the agreement oblique contracts with your client. However, to ascertain the contents of your letter, we would request you oblique your client to provide us with the following. One, copy of the multiple contracts subsisting between you and your client, between us and your client. Then 2, copy of the communication recalling the loan alleged disbursed to us, copy of bills, invoices, copy of GST paid, details of disbursement made to us in our account with account details, details of the last payment by your client. On receipt of the above information and document, we shall examine the same for necessary action and detailed reply to your good self, your client. There is no mention of any award at all. Then, my lord, sorry, কিছু আমি যদি মিস করি আমাকে বলে দিন। Then, my lord, kindly come to then, my lord, I have shown to your lordship the affidavit reply from which we got the information. Then, my lord, the awards have been, the copies of the awards have been enclosed. I am not going to trouble your lordship with this. Then, my lord, kindly come to, since I am on the petition, I just want to complete this. Kindly come to page 347. After we came to know of it, my lord, this alleged award, this is the letter was written by us to আমাদের চিঠিটা কোথায়? At page 347 is my lord, at my lord, kindly come to page 325 once.
After we come to know of the
Yes, after we came to know of this alleged awards, page 325, 1st March 2024, addressed to the arbitrator. We are representing Shrey Equipment. The solicitor is writing. One of the borrowers of our client, namely Roadwings International, is in default and proceedings have been initiated by our client. In a proceeding under Section 7 of the Insolvency and Bankruptcy Code, the said borrower in its reply filed thereto has disclosed 2 awards dated so-and-so and 17 September and 21st September 2020, which is stated to have been published by you. For your ready reference, copies of both the awards are enclosed herewith. Since our client has undergone CIRP and there is a change in management, upon such awards being disclosed in the reply affidavit by the borrower, a thorough check has been conducted by our client, but no records of such arbitral proceeding could be found. In such circumstances, on behalf of our client, we hereby request you to kindly provide us with a complete set of entire arbitral proceedings, culminating in the aforesaid 2 awards as relied upon by the said borrower. Please treat the letter as urgent. Any cost for issuance of such 2 copies of the arbitral proceeding shall forthwith be borne by us. This letter was replied to at page 345. Well, at page 347, dated 5th March 2024. The arbitrator is writing to Kanodi and Company, arbitration between so-and-so. This has reference to a letter dated so-and-so received by me on 4th March 2024, wherein you sought certain details on behalf of your client so-and-so. In the said matter, I have passed award dated 17th September and 21st September, in which it may be noted that the following charges as details below are pending from your client, Shrey Equipment Finance Limited. Award dated 17 September 2020. I have shown to your lordship this letter. Arbitrator's fee, claim amount 1,89 lakhs. Fee for study of the pleadings, cause materials, work award, etc. Then venue, secretarial assessment, 70,000, 65,000. Conveyance charges in respect of 1 award, and in respect of the second award, again, my lord, the same amount of money. Or, my lord, slightly different, and it has been claimed. The above mentioned fee and other charges totaling rupees 1,18,000, 11,82,946 may kindly be deposited by your client, Mrs. Shrey Equipment Finance Limited, in our favor. The bank details are below. I will pause here for a moment. Your Lordship, please to see, according to them, the 3 days of hearing took place. And my lord, 11 lakhs of rupees what is being claimed from us. I do not know that whether it is the entire amount on me or only our part of the claim is sought to be claimed. We are not aware of anything.
What বলছে respective costs?
This particular document does not say whether this is our part of the claim or rather our part of the charges or it is that both for both. We do not know. But it seems a rather abnormal amount has been claimed for 3 days of hearing. I mean, assuming, my lord, a venue was taken, secretarial assistance was taken, even then, my lord, this is too much of a claim. Anyway, this has been claimed from us. Then, my lord, to that we wrote, my lord, on 11th March 2024. Your letter dated 5th March. We are in receipt of your letter dated and had forwarded the same to our client. Page 3550. We are writing this letter to you. Our client, Stray Equipment Finance, has undergone corporate insolvency resolution process. By virtue of an order dated 11th August 2023, a resolution plan has been approved by National Company Law Tribunal, Kolkata bench, and an implementation monitoring committee has been formed in respect of our client. However, in terms of the approved resolution plan, new board of Stray Equipment Finance Limited is duly reconstituted in February 26, 2024. With the new management, our client is now in the process of looking into the records. Our clients request you to kindly provide the following: your Aadhaar card, your PAN card, a cross-cancel check, copy of the minutes of the meeting wherein the fees of the arbitrator and other expenses have been determined. Then copy of the letter appointing you as the arbitrator and requesting you to enter upon the reference in the matter. The aforesaid document will enable us, our client, to look into you also expedite the whole process. You are also requested to provide the necessary postal receipt for delivery of the award in question upon our client. And the reply was given at page 352. Addressed to my advocate on record. Acknowledge receipt of your letter. I write to bring to your attention the outstanding fees and charges totaling rupees 11,82,000, which remain unpaid despite my prior communications. On 5th March 2024, I provided my bank details for the purpose of remittance with copy furnished to your client, Mrs. Stray Equipment Finance Limited. In the light of the aforementioned, I request you to expedite payment process with your client. It is imperative that this matter is resolved prior to any further correspondence regarding the arbitration award, dated 17 September 2020 and 21st September 2020 between Stray Equipment and Road Wings, wherein I have become functus officio after passing of the award and returned all documents to the parties concerned, retaining the original award with me. So, my lord, all documents have been returned to the parties concerned, retaining the original document. My lord, kindly note one thing, that here we do not have any other record excepting the 2 awards. Kindly note the second paragraph. This is what had been churning in my mind. On 5th March 2024, I provided my bank details for the purpose of remittance with a copy furnished to your client, Mrs. So-and-so. I pause here for a moment. My lord, when the arbitration takes place, I just tell your lordship from my own experience. In the first meeting, the bank details are given. The mode of payment is recorded. And my lord, in the minutes, my lord, it is recorded with regard to the payment of the fees. I wonder why at page 352, the arbitrator will write that on 5th March, I provided my bank details. Why is it that if the meetings have been held in the regular course of business, why is it that she has to write that on 5th March 2024 I provide? She should have written that, look, at the meeting held on such and such day, In the very first day, I had provided the bank details. Why have you not, in spite of it, paid? 3 days of hearing had taken place. There is not one letter, nothing. And my lord, this letter is being written for all this, my lord, in the month of March 2024. Long 4 years after, my lord, there's not one letter with regard to this, that you are not collecting the, you are not receiving the signed copy of the award after payment of my fees. Why is it that you have not paid my fees for all these months? Nothing of the sort. And my lord, only after, my lord, my advocate on record has written a letter to her, for the first time she is coming up with this. This itself is a suspect. I submit to your lordship.
How did they get a copy? If they said they are not the original,
My lord, my learned junior rightly points out that how is it that they got did they pay their dues? This amount of rupees 11 lakhs, is it my share which I did not pay, therefore I did not get this? Is it that they paid their share and therefore they got their the awards? Well, all these questions arise. I am just raising these questions for the purpose of making this submission that the whole issue has become is a suspect. It's absolutely shrouded in mystery, as I submitted to your lordship. Now, my lord, after this, the new management had been able to recognize, had been able to locate some of the records. My lord, those records are part of a supplementary affidavit which was filed on behalf of the claimant. On behalf of, my lord, the petitioner. This supplementary affidavit is
The document. Petition is approved.
kindly give me 1 second. Yes, my lord, kindly take the supplementary affidavit. I'm not troubling your lordship with we have said that on searches, further searches being made, these have been found. This is, my lord, a thick volume.
এগুলো নয় তাহলে, এগুলো
It is marked as supplementary affidavit.
Yes.
Your got that. I take your lordship straight away to the well, to the annexes. Well, at first few annexes with regard to the agreements, etc. I'm not troubling your lordship. Well, kindly come to page. Yes, kindly come to page 94. This is, my lord, prior to, as a precursor to section 9 application, this notice of demand was given. On 23rd May 2018, page 94. This, I am not troubling your lordship the entirety of it. This is agreement number, kindly note, 130853, dated 25.
because name of oil Chakraborty is there.
Yes, my lord, this Oyen Chakraborty was the advocate who was then, my lord, giving notice of demand. This is the first notice of demand. Then, my lord, kindly come to page 97. This is dated in date about 23rd August, I think, or something, or 23rd May. Again, my lord, with regard to 130853, notice of demand. Similar notice of demand in the other one also. Then, my lord, the order of, as I told you, lordship, section 9 application, order of Justice Chakraborty.
103 ta dekhiye.
Then, my lord, here lordship kindly comes to the second paragraph at page 100. Mr. Indradeep Basu, learned counsel appearing for the respondent number 1, produced an electronic mail dated 16 July 2018, wherefrom it appears the respondent wishes to make over the possession of the hypothecated asset to the petitioner, and a copy of the said electronic mail dated so and so be kept on record. In view of the above submission made, the hearing of the application is adjourned. Then, my lord, page 102. On 14th August 2018, in the same application, this order is paid. It is submitted by Mr. Banerjee. Mr. Shataru Banerjee was appearing for the petitioner, my client, that learned advocate appearing for the petitioner, that the petitioner does not wish to press the application. Accordingly, so and so stand dismissed as not pressed. Well, what happened, my lord, we do not know. It is quite possible that the machine was made over. So, my lord, the application under Section 9 became infructuous. So whatever it is, my lord, I am not on that. So this is what happened, and it came to an end. Then, my lord, kindly come to page 103. 30th April 2024. Then Oyan Chakraborty, my lord, this letter has been written by Mr. Chakraborty after, my lord, it was said in the award itself, my lord, your lordship sees the name of Mr. Oyan Chakraborty is there. So we wrote to them that how are you involved in this arbitration? And this is the reply he is giving.
Could not have been made over in 18 because the award.
I do not know.
No, award notes. Its valuation was done in March 2020.
Yes. Yes, I stand corrected there. My lord, I said that perhaps it was made over, but my Mr. Bose points out that it could not have been made over because the valuation of the machine was made
in March, according to the award. In March.
And that had been made in the month of March before the, yes, 2020. And my lord, 75 lakhs of rupees was valuation made, and that was given credit in the award itself. So, my lord, I don't know why this happened. But this is happened. This is on record. I do not want to put my case higher than what it is. Then, my lord, page 103, 30th April 2024. Mr. Oyan Chakraborty is writing to Strafe Equipment. There was an email of 22nd April 2024. I could not find that email. Written to Mr. Chakraborty that to clarify the position. And there he is writing, I perused your email dated 22nd April. To the best of my knowledge, and upon reviewing my records, I certify that no reference has ever been made involving contract number so-and-so, so-and-so, so-and-so of the borrower, Roadwings International Private Limited, as well as that I have never taken part in any arbitration proceedings regarding the above referred borrower and contract number so-and-so before Honorable Justice Bandana Ray, Session and District Judge. This is the letter which we have disclosed in our supplementary affidavit after we have discovered it. Then, my lord, there is an important letter at page 104.
Before when it was before administrator.
This is, my lord, also written by the administrator when it was under the administrator. Addressed to Roadwings on 22nd September 2022. This is, my lord, dated 22nd September 2022. Perhaps your lordship will not be able to.
Page 104.
My lord, at page 104.
20th September at the top left.
20th September. Oh, date 27. Yes. My lord, your lordship is right. Yes, 20th September 2022. Correct. Then, my lord, here, your lordship sees that, my lord, the letter is being written, as your lordship will please to find, at page 106. Authorized signatory is writing this letter. This has reference to letter 16 July, which is at page 109. I shall show to your lordship. The contract number so-and-so is booked in the month of so-and-so, amount is disbursed to your client so-and-so. Kindly see Roadwings International, that block is there. And 138524 and 130853, these are two contract numbers mentioned in the list of contracts. And there, the amounts have been mentioned also. And the total has been given, the engine number have been, the machines have been there given. Then please find the outstanding position at page 105. First, second, third paragraph. And there again a chart, and 130853 and 138524, and the respective amounts have been mentioned in that. One is 30 lakhs.
No.
3 crores.
3 crores.
1,55,013, and the other is 1 crore 4,94,000 and odd. Then, my lord, the
Commas has
last,
been put in the US style.
my lord,
Yes.
yes,
Commas.
comma has
Mi-
been put in
millions.
yourself. My lord, I become always
believe
get
in
confused.
Yes.
Uh,
Pardon?
They believe in millions.
Yes,
We
they
believe in
that,
crores.
right,
We
right.
talk in
Millions,
crores.
right. Exactly. Exactly.
I don't.
No,
I
you don't
talk
believe
in
in
terms
either.
of either crore or
Either.
million. I always come to read 30 lakhs or something.
You don't believe in either, and we have no scope of believing in either.
The same
Unless
here.
it's coming from that side.
Same here on this side also. Kindly, my lord, see the last paragraph.
Yes.
Hence, your statement under the said letter are totally afterthought and denied in toto, and you are further requested to clear outstanding dues payable by you, as mentioned above, failing which we shall be constrained to take and continue all necessary actions as per applicable laws, and shall also be entitled to exercise our right as per the provisions to recover the legitimate dues. Well, Lord, kindly note this, that this letter is being written in reply to the letter at page 109.
এক মিনিট তলায় দেখিয়ে দাও কে লিখছে তলায়
Authorized signatory.
না 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 দিস পোর্শন লেটার হেডের তলায় একদম
Corporate insolvency resolution process is there.
না না দিস ইজ ইম্পর্টেন্ট আ কোম্পানি আন্ডার কর্পোরেট
Right, so Shaita to put it, the last sentence, the same thing is written at the
Right
bottom
at
of
the
every, yes. Under the company, this thing.
Yes, yes.
yes
All
that, that,
right.
yes.
Now, my lord, this letter refers to your lordship sees, this has reference to your letter dated 16 July, your lordship sees this. This is, my lord, is an enclosure to another letter written, which I shall come to back afterwards. Kindly come to page 109. Your letter dated 16 July, Shrey is writing to Road Wings that your letter dated 16 July, and this letter is 16 July at page 109. Release agreement 133 so and so expired on so and so. This in connection have been requesting so and so. This is in respect of another contract. Kindly, my lord, ignore this. Then, my lord, come to the next one, page 110. This is with regard to another agreement. I am not troubling your lordship with this. Kindly come to page 111.
No, not even that.
পরে পরে
That is a subsequent document which is enclosing these letters. Lordship will please to come to page. I am not troubling your lordship with the other letters which
Sure.
are in respect of other
Other
contracts.
contracts, yes.
Kindly, my lord, come to page 114. These are all enclosure to a letter, covering letter to which I shall come afterwards. 9 June 2021, page 114. This is outstanding dues with regard to 130853. The demand letter Shrey is writing. Then, my lord, page 115 also, demand notice with regard to the other one, 130853. In respect of one, this is with regard to the same one, 114 and 115, the same one. This is a demand notice in respect of this. And then, my lord, with regard to the other one, this your lordship will please to find at page 119. Page 119, this is with regard to 138524. 34 lakhs 8,000. That has been, this is a demand notice. So that these demand notices, my lord, are there. And these are enclosed to a document, which is very important document in my respectable submission, dated 7th October. This, my lord, I will request your lordship to look into page 107. 107, my lord, encloses these documents. And this is Road Wings International letter, addressed to the administrator. As an administrator, we hope and trust that you will view the entire situation neutrally and without any bias. Thereafter, the word malafide intention as stated in Shrey's letter appears inappropriate. As you are aware, Shrey has been caught red-handed in various scams, and therefore their version does not deserve to be blindly trusted. In reply to the contents of your letter, kindly note that there is no link between Roadwings International and Highway Road. I am not troubling your lordship with this. The directors and shareholders of both the companies are also not common and not associated in the shareholding pattern. It is also not acting as a part of a group as such, etc. Well, I am not troubling. Next paragraph. As regards other contents of your letter, we have already surrendered all assets and have already explained our position by our letter dated 16 July 2020, copies of which are again enclosed for your ready reference as Annexure A. And these are the letters which I just now showed to your lordship, 109 to 111.
But here they rely on a particular letter which does not refer to the agreement. These
Yes, yes,
it also does.
yes, it does.
16th July, where is that?
I shall just here look, these letters, my lord, referring to these contracts, Annexure A is, my lord,
Annexure A is at page 110.
110111.
Yes. But
Yes,
you
this is with regard to the Lok Adalat case.
so not referring to any specific agreement.
No, kindly, my lord, come to the subsequent.
Contract numbers are given at page 111,
Yes, my lord,
which is a different contract.
yeah, these are two different contracts. So I didn't trouble your lordship with this.
Yes.
Kindly, my lord, come to, before reply in details to the contents of your aforesaid letter, we would request you to kindly to provide us with the following: copy of the proposed forms signed by us for all the above alleged contract, copy of alleged agreement. It was not being provided to us nor signed by both the parties. Sanction letters along with rental details, proof of disbursement and of full amount to us, or authority given to supplier to pay, if any, for up-to-date statement of account in the contracts. Then, my lord, kindly turn over the page.
Next page, the adjustment, under the adjustment head, those
Yes.
contracts have been.
Then, my lord, page 108. It is also observed that SREI have adjusted our payment made against many contracts with some other client of SREI. In your letter dated so and so, you have claimed an amount of rupees 1 crore 28 lakhs towards contract number 133798. This is not our contract. The figure has changed to so and so. Annexure B. Then, kindly, these two paragraphs are very important. Next paragraph. In your letter dated 9/6/2021, you have earlier claimed an amount of rupees 1 crore 51 lakhs towards contract number 130853. But on 20/10/21, you have claimed an amount of rupees 92 lakhs 23,000. Copy of the letter is attached as Annexure. This is at page 114. So this Annexure C, they have enclosed our letter of demand in respect of this contract. And this is the reaction that they are saying.
114 and 15.
114 and 115, my lord, I have shown to your lordship. My lord, kindly just make a note of that. So this is, my lord, subject matter of the dispute between the parties. Here, my lord, what they are saying is purporting to show the discrepancy between the claims which have been made. Then, in the next paragraph, I am not troubling your lordship. This is not the subject matter of it. Then the next paragraph, 4.
Deals with another.
Yes, in your letter dated 9/6/2000, you have claimed rupees 67 lakhs against the contract number so and so. But as on 2010 to 2021, the figure has changed to rupees 34 lakhs. Copy. Well, I just pause here for a
This is
moment.
page 119.
Yes, that is 119. Well, kindly note,
Yes.
by this time, in respect of these two contracts and awards have been made. One award is 17th September, the other award is 21st September, both in 2020. Not a whisper. Nothing absolutely with regard to it. I shall show to you actually what they have ultimately said. What they are showing is discrepancy. They are not saying that there is an award, nil award. Therefore, what are you claiming?
Discrepancy and reconciled, adjusted these words.
Next,
Previously adjusted, then reconciled.
Kindly note this. We have reconciled the account. My lord, this next paragraph is very, very important.
Yes, marked.
Reconcile the account with your vice president with a copy to President. The then CEO in mail dated 20th August 2020. Copy of the mail of Sri dated 20th August 2020 is attached as Annexure F, from which it is revealed that your letter dated 20th September 2020 is full of anomaly, and an attempt has been made to put our company in distressing situation. Now I pause here for a moment. This is dated, your lordship can mark it at page 120, 20th August 2020. Kindly see the,
Just 10 days before the award.
kindly may not see, this is 20th August 2020. I shall come to the date afterwards. Kindly look at this. Well, I don't know whether your lordship will be able to read it. I don't know how your copy is. My copy is very bad.
It is
I've taken down on the last occasion.
we have made a
In larger, very large.
No, would you follow? The date I can't find.
Well, here,
This I can decipher with up to this, but the date I can't find. I took down on the last occasion 20th of August 2020.
20th August, yes.
That
Lordship,
date I don't find in this.
And voter annexure is signed. Okay.
well, kindly come to the block, the chart which
Yes.
is given. The first, second, third, fourth, live. Your lordship sees
Yes.
fourth entry is 130853. Our contract. Roadwings International, OD amount 1 crore 90 lakhs 15,710. Future dues 9 lakhs 7,000. Total is so and so. And then one after that, live refinance contract. Again, 138524. Your lordship sees that the number.
Yes.
There again, 30 lakhs 76,000 and all. Then, my lord, surrender sold. I'm not troubling your lordship for the time. Kindly, my lord, come to clients had offered 14 lakhs in Lok Adalat to settle the loss on sale of a dozer. Contract number 138478. This was the subject matter of Lok Adalat. I'm not troubling your lordship against contractual liability of 85 lakhs. Then, my lord, liability as per Srei. 12 crores, 12 lakhs, 47,691. Live contract. Kindly note live contract. 12 crores and all. Repo and sold asset, 3 crores, 73 lakhs. Then total liability, 15 crores and 12 lakhs.
86.
12 crores, 15 crores, 86 lakhs. Then disagreement with the client, that has also been given.
No arbitration.
My lord,
mentioned in-
kindly see, my lord, there is the disagreement with the client that has also been said, and this is being written to them, and they are accepting this statement. And after, my lord, giving credit for this disagreed amount, 7 crores 73 lakhs 8,678, the claim was 8 crores 13 lakhs and odd. Then asset security,
We reached that.
3 rich stackers
1 crore.
and 1 flat at Alipur. That had been given, total tipper, total coverage.
Then asset liability mismatch.
That asset liability mismatch negative so and so. Now, my lord, this is a document which has been given on the 20th August 2020. And my lord, remember the dates of that award, 17th September and 21st September on the same
We
year.
are concerned only with two of
So, my lord, this is the account which they have referred to in that paragraph at page 108. Kindly come back to page 108. We have reconciled the account with your vice president, with a copy to the president. Then CEO, mail dated 20th August 20. Reveal the letter date so and so, a full of anomalies. Then, my lord, kindly come to the next, upon receipt of the above document, we would be in a better position to assist your good self in properly analyzing factual situation and whether there is any truth in Srai's statement. We also do not understand as to why the claim against other companies have been clubbed with our company, since there is nothing. All the companies, well, kindly note one thing, that when this letter is being written,
7th October 22.
7th October 2022, already the award has been made. And when this account was given, which is at page 120, then, my lord, the arbitration was going on. The 2 dates of arbitration, May and July. So, in fact, my lord, arbitration had concluded by that time on 20th August 2020. But a normal person would have said that, look, what are you talking? Why are you including this? This is a subject matter of the arbitration. Hearing is concluded. Award is awaited. Why is it that you are claiming this amount of money? Nothing of the sort.
But they say reconcile with your vice president, rather, not relying on the award.
Not relying on the award at all. No
Get your
mention of the award. So this was our, my lord, in the opposition. I will just show you one paragraph in the opposition. My lord, this is, my lord, affidavit in opposition, para 20, subparagraph 20. This, they have dealt with this. This particular letter, opposition is dated. This is not very thick.
No, not very.
This
30th July 24.
kindly come to they have stated their facts, the so-called facts, my lord, in para 20, which starts at page 6. I will request your lordship to come where they have dealt with this particular aspect of the matter. First, kindly come to page 10, subparagraph 9. Page 10, subparagraph 9. That the hearing of the arbitration proceeding commenced before the learned sole arbitrator appointed aforesaid from January 15, 2020, and were continued in further sittings held on 8 May 2020 and July 3, 2020. So both are, my lord, just before this
20th of August.
20th of August. That during the pending of the arbitration proceeding, the hypothetical assets, subsequently the respondent surrendered the hypothetical assets. Then, my lord, kindly come to subparagraph 20 at page 13.
Yes.
Subparagraph 20, XX, double X.
Hmm.
That the petitioner thereafter, by letter dated 20th September 2022, once again demanded from the respondent to clear the outstanding dues under various contracts, including contracts entered in between the petitioner and and other entity. Therefore, the respondent being perplexed on receiving the said letter, respondent by letter dated 7th October 2022, once again reiterating that the respondent's accounts with the petitioner had been reconciled, settled, the respondent sought for further clarification on various contracts under which the petitioner was claiming amounts due, and requested the petitioner to communicate with respect to the respondent's dues only, if any. Copies of the said letters dated 20th September, 7th October are annexed at page so and so. This letter, then, my lord, at page subparagraph 21. This letter dated 7th October 2022 of the respondent is being wrongly camouflaged as an admission of the allegation that no arbitration proceeding had culminated into an award, and that the respondents had accepted that the purported sum of rupees 8 crores 13 lakhs, that is in the statement account, the last entry, was due under a purported reconciliation account sent to the respondent by the petitioner as in an alleged email. It is stated, and this is what they are saying, that the aforesaid purported reconciliation of the accounts contain various contracts under which the amounts were due. Kindly note this is an admission. Further, the fact that the underlying contract, being contract number so and so, was alive is a statement made by the petitioner, which in no event can be said to be an admission on the part of the respondent. The respondent has accepted that particular statement, which contained the statement that it was alive. Then, how can they say that there is no admission on my part?
When they are admitting the letter.
They say there was a reconciliation. You don't say. You make the claim.
And they're saying this is the reconciliation
It
in their
perplexed
letter.
because you make the claim despite the award being already there.
Yes.
But in their reply, 7th October is admitted. And I mean,
The
the
annexures
And
also
7th
said-
October, my lord, there is not a whisper about
in
this
that letter itself, they say that there was a reconciliation with the vice president.
Right.
They are relying on this. This is
And
an
and they are,
annexure.
my lord, relying on the reconciliation for the purpose. This is, I submit to your lordship, my lord, that this document stands admitted. My lord, after we have disclosed this is in our supplementary affidavit.
And before the administrator. Which is
And
more-
this was before, my lord, the administrator. There is no question of, well, at that particular point of time, any sort of allegation of fraud, unnecessarily you are imposing liability upon me for which I am not liable. All these issues, my lord, this is the administrator on the basis of the records available, he was making a claim. And my lord, in normal circumstances, in a normal situation, if, my lord, what is being adverted to before your lordship today had been correct, the simple letter would have been, what nonsense you are talking about. Look, these are the two awards in which the entire amount of has been disputed and been denied, and the arbitrator has held that nothing is due and payable. So why are you claiming? Simple answer, nothing more. All these longs, annexures and all that.
Why do you have
And
to
this
disclose
only goes to show that this entire story of my lord, award is a suspect.
This opposition was to the supplementary affidavit.
No, this is the
Combined.
Yes, the
Combined.
petition and the both. No, my lord, they came out with
No, ওটা দরকার নেই।
they came out with, my lord, an application. I am not troubling your lordship with a supplementary affidavit because they have made it a part of this application. The respondent's application to bring on record the additional evidence. Well, we did not. They wanted to rely upon this. So,
যে প্রেসটা দেখিয়ে দেখো
my lord, this application was made after, my lord, 2 days of submissions have been made on 18 September 2025.
একটা হচ্ছে they do not want the supplementary affidavit which to be as part
ঠিক আছে, ওটা সেটা নিয়ে তো
না, সেটার মধ্যে অনেক ডকুমেন্ট
না,
আছে
সেগুলো শুধু এখন তো they have annexed it also.
হ্যাঁ so we have not dealt with the supplementary.
Your lordship sees, my lord, here leave be granted to the respondent to bring on record the documents being annexed A, B, and C to the present application, and liberty be granted to the petitioner to refer to and rely upon the said document at the time of hearing of this petition. Now here, আচ্ছা, ওটা আমি জানি।
ওটা ডিলটা করে দিন হ্যাঁ ওদেরই ভ্যালুয়েশন যে আমরা ভ্যালুয়েশন
My lord, kindly come to page 8 of this. And
yes
this is, my lord, the notice. This I have also placed before lordship earlier. The 20th May 2019, they have disclosed that where we proposed that Bandana Rai, retired district and session judge, should be the arbitrator. And this is written by Vivek Bharadwaj. We have dealt with this, the chief manager. Then, my lord, kindly come to next letter. Which is dated 29th December 2019 and addressed by them 5 months thereafter. Kindly note our alleged letter is 20th May, and then 29 December 2019 they are writing, we hereby give our consent to you to act as an arbitrator in respect of the contract. My first submission is this before your lordship, that this is supposed to be a hand delivery letter, very well, hand delivery letter. I would submit to your lordship, my lord, there should be first a letter to Srimati Bandana Ray by us. And thereafter only this letter can come, that we are consenting to what has been said. First. Number two, a letter has been written, section 11 number
মানে জয়েন্টলি অ্যাওয়ার্ড বলছে জয়েন্টলি
না না তুমি
ওকে
পরে আসছি, তুমি আগে এই
section
section টা পড়ো। This is a letter which is being written without any reference to any letter having been written by Srey to Bandhana Rai. We hereby give our consent to act as an arbitrator. So, my lord, she must have been told by one letter, another letter. Copy must have been given to, my lord, the road wings, on the basis of which, my lord, they must have written to Bandhana Rai that you have received one letter from the claimant.
Bandhana is not brought into the loop. I mean, you write to them and they write to Bandhana. There's no link.
And there is no copy, either
Copy to either.
No,
either
neither of them copy given to the other side. This is a very peculiar way of appointing arbitrator.
We do not have this in our records.
Did not have, we don't have.
দেখো তো কোথায় রয়েছে, 1 মাসের মধ্যে ওদের দিতে হবে, কনসেন্ট করতে হবে।
আমি যদি অ্যাপয়েন্ট করি,
হ্যাঁ হ্যাঁ, দেখো এখানে।
আচ্ছা, হ্যাঁ, দেখাচ্ছে।
Then, my lord, the next document is also very important. This is a document which is signed by Mr. A.K. Ray, who was, my lord, a person who was
In charge of.
unfortunately suffering from. This is there, my lord, in this connection, before I move on to the next document, my lord, kindly see section 11, subsection 3, capital A. Or I should say 4, subsection 4 of section 11. If the appointment procedure in subsection 3 applies, and a party fails to appoint an arbitrator within 30 days from the receipt of a request to do so from the other party, or the two appointed arbiter fail to agree, the appointment shall be made on an application of the party by the arbitral institution designated in Supreme Court in case of international commercial arbitration, or by the High Court in case of arbitration other than international commercial, as the case may be. So, if within 1 month, my lord, appointment is not made, then the party who has nominated the arbitrator, he can apply to the High Court that this party has not consented to the appointment within 1 month, therefore appoint this arbitrator.
But still, this does not prevent any of the parties later on to agree.
Yes, of course.
So
What I say is,
might have been taking their best case
Yes.
that no section 11 was filed, but they agreed after
let me put it this way.
7 months.
I quite understand this, but what I submit, I put it this way, that the petitioner before lordship was eager to have the amount ascertained before an arbitrator, adjudicated by the arbitrator.
Yes.
And he was interested in going to arbitration. This is the story. This is the picture. Now, my lord, if that is so, and if he has made an suggested an appointment, and the other party is not responding to it, then I would have expected either, my lord, that there should be a letter of demand. Look, I have already suggested a name. Why don't you agree to it? If you don't agree to her, then why don't we agree to somebody else so that we can jointly go before the arbitrator? Because the claimant is sought to be, my lord, put up, my lord, as Shrey. And if, my lord, Shrey was interested in having its claim adjudicated, then, my lord, he wouldn't have waited for 5 months.
7 months, actually.
7 months without a single, my lord, letter of demand, letter of reminder.
Doing nothing, basically.
Did nothing, absolutely.
No alternative arbitrator.
Yes, well,
section 11.
here in a situation, the reason why I'm relying upon subsection 4 is this, that if Shrey was interested in having an arbitrator appointed in the matter, then, my lord, he would have, they would have applied under subsection 4 before the High Court for the purpose of appointment. I say that, I agree that if you appoint 5 months thereafter, or 7 months thereafter, or 1 year thereafter, and if this party is agreeable to wait for that long, I mean, it won't ultimately matter once you agree to the appointment. But then again, my lord, look at the totality of the situation. Where the parties were at, I mean, I shouldn't say loggerheads, but they were, my lord, acting in a manner, my lord, in which both of them were, so to say, eager to go before an arbitrator or an adjudicator for the purpose of deciding that claim between the party. So I just wanted to draw your lordship's attention to this for the purpose of showing your lordship the what should I say, absurdity of this situation in this. Then, my lord, page 10. This is something, a new discovery, according to them, because, my lord, this gentleman, Mr. A.K. Roy, was suffering from cancer. So this could not be discovered at that time. This dated 8 December 2020,
Immediately after the award.
Stray equipment being made. Soon after this so-called award had been given, request for removal of charge on ROC Civil. Dear sir, as you are aware, the arbitration was held between our company and Stray Equipment. A copy of the arbitration order dated so and so towards agreement number so and dated 15th July, dated 15 July, and arbitration order dated 17 September towards agreement dated so and so is enclosed. In the wake of the above, you were requested to remove the charge.
You don't admit the receipt of this.
No,
No,
we
of
don't
course
have
not.
it in our records.
It is not on, not in our records
This
at all.
No postal receipt or anything has been.
No, no,
annexed.
this-
Nothing. This is
hand
the
delivered.
Oh, acha, acha. Oh, receipt.
this
Yes.
is the hand delivery of a letter
This
which has
person,
been sent. Well, what happened to this person? So I shall place my affidavit in reply to this discovery.
What is the
Well,
name?
I only
Karthik?
asked
this person is no longer.
What is the name?
some
Signature? I can't.
Agarwal or
No, no.
something like that. Black one, that one.
Well, then the reply.
Reply. I shall show to your lordship what is
Very
the
good.
name of this person. Well, I only say this,
The date.
that had it been actually given to us, then, my lord, this should have been the first. And, my lord, see, the gentleman, my lord, who was in dealing with it, Mr. Adip Rai, excuse given is this, that he was ill, and therefore he could not. Therefore, we could not trace this. My lord, kindly come to page 23 of this. These are the medical report of Mr. Adip Roy. What they have said. Well, I think what I shall do is this. Kindly see their supplementary affidavit. This supplementary affidavit they have annexed to their application. Kindly, my lord, come to page supplementary affidavit, which is enclosed with their application.
Yes.
They kindly, my lord, come to
Page
page 14,
Yes.
paragraph 2.
Hmm.
Mr. Adip Kumar Ray, executive of the respondent, has all along been responsible for maintaining the record documents of the respondent. However, he was indisposed and undergoing treatment at the time of filing affidavit in opposition on behalf of the respondent in AP number so and so. Therefore, certain documents could not be filed along with the affidavit in opposition. Copies of the doctor's prescription, etc. Supplementary affidavit is being affirmed to bring on record certain documents which are important and relevant for the proper and complete adjudication. Now, my lord, Annexure A, my lord, the medical reports of Mr. Adip Ray had been given. My lord, kindly come to page 23.
Yes.
Surgery performed. About the middle, surgery performed. Your lordship has got that.
Hmm.
Left-sided intra so and so, gastronomy reconstruction so and so on 2nd May 2024. 2nd May 2024. Kindly remember the date.
Hmm.
Kindly come to page 22. The date of admission is 30th April 2024.
Hmm.
And, my lord, date of discharge is 6 May 2024.
Hmm.
So after the operation, 1 day thereafter. And then, my lord, after he had been discharged, so, my lord, he was there from 30th April to 8th May 2024.
6th May.
No explanation has been given as to why. He was not in a position to look into the documents and give these documents, my lord, at the time when they filed their opposition.
When did they file the opposition?
Well, they filed the affidavit in opposition on affidavit. I shall give your lordship the date. No.
I shall give you.
Mr. Mitra, just take a break of 5-6 minutes and then come back and take the date and
15, 16.
The letter that you're showing now is there with para 16.
16 আর আগেরটা
14 14
14 আর 16
14 থেকে 16 দেখলেই হয়ে যাবে ওর letter. And regular letter, regular
14 আর 16 14 তুমি 14 দেখছো না 14
প্রথমে বিবেক ভারদ্বাজ
বসো
আর 16 হচ্ছে
14টা দেখেছি আমি। হ্যাঁ আর অন্যটা হচ্ছে
They filed an affidavit opposition to the main section 34 also.
yes
combined.
combined
That combined.
Yeah,
This.
that's the combined one which your lordship has seen there.
This was 10th of December 25.
Yes. No, no, not that.
No, no, that is Aditya Kar.
30th July 24.
In the
Yes, 30th July.
Yes. July 24 maybe is the one that your lordship now I should
Yes, yes.
try yours to make. Lord, lordship will please to. I was on my lord. The application.
No, you are probably indicating, Mr. Mitra, that if he was in hospital up to May 2024, 6th May, so what prevented him from disclosing this on 30th of July 2024?
Yes, I am saying, my lord, from April, your lordship kindly takes that.
30th April to 6th May.
He was in the hospital.
Yes,
He must have been suffering before that.
obviously.
But then, my lord, we have not been told for how long he was not there. And but after he had, my point is this, after he had recovered, he had been able to discover these documents. Then, my lord, why is it that these documents, when he was well, why is it that, because what they are saying is that he was in charge of the arbitration. He was in, kindly see what they are saying. In the respondent's application, my lord. Can you give me 1 second? And গাদা কাগজের মধ্যে কোথায় রেসপন্ডেন্ট সাপ্লিমেন্টারি অ্যাফিডেভিট কোথায় গেল অ্যাপ্লিকেশন ফর ইয়েটা কোথায় গেল
G1
সাপ্লিমেন্টারি আমি তোমাকে গুছিয়ে দিচ্ছি গুছিয়ে না
That is page 14.
ইয়েস
of this application.
সরো তো এক গাদা ব্যাকটেরিয়ার মধ্যে তুমি এগুলো হ্যাঁ এইটা বোধহয় দেখো তো এয়ার খুঁজে দে একটু But when I get lost in the papers, then I start feeling that perhaps enough. Well, kindly see, this document is I'm just proceeding on the basis of there. He says that paragraph 3 of that application, J1 in 529.
G1.
Respondent's application to bring on record the additional, where your lordship please to has been just now noticing, my lord, his medical report.
Yes,
Yes. Lordship will kindly come to para 3 of that.
yes.
of the application.
Page 3 of the application, para 3.
Yes.
The person in charge of the arbitration proceedings was diagnosed with carcinoma and was undergoing treatment for a substantial period of time. Upon recovering, the said concerned personnel of the respondent company was requested to find out if there were any record of the arbitral reference available with him. Upon carrying out searches, Mr. Ray, the authorized representative of the applicant respondent, could find out some relevant documents. I pause here for a moment. Well, I've got full sympathy for the gentleman who was suffering from cancer at that particular point of time and was under treatment. Well, first of all, my lord, it has not been stated since when he was out of the office because of his illness. From the record that has been disclosed, as I showed to your lordship, from the record that has been disclosed, it seems that he was admitted on 30th April 2024 and he was discharged on 6th May 2024. So barely for 6 days he was in the hospital for surgery. But he must have been ill before that, and he must have taken some time to recover. Well, giving him that, it has not been said how long he was there, number one. Number two, after he recovered, then if he is the person who was in charge of the arbitral proceedings, I would have thought that he would be the person who would have come forward with, my lord, an affidavit saying what transpired in the arbitration proceedings. When did it take place? Where did it take place? What happened during COVID period? Did he attend himself? If he did not, then who else attended? Nothing has come forward. Even though it is being said that he was in charge of the arbitral proceedings in paragraph 3.
The documents which I have disclosed to negate the award are not signed by him. From raw doings. আমরা যেগুলো
Well,
reject
I
করেছি,
also would like to see how many of this, after all, if he had been an officer and if he had been in charge of the arbitration, then my lord, definitely the documents would be signed by him. And if he is the person who knew about the things, then he would have been the person who would have said that, look, this particular claim is not maintainable because it has already been settled by and between the parties. Particularly, award has been passed against the claimant. That is not there. And my lord, these documents which have been enclosed now, with this, we have, my lord, reacted to this in our reply. Opposition, or rather opposition. In our opposition to this. That's about.
Oh, আচ্ছা। অপোজিশনটা এক্ষুনি দিলাম তোমায়, হ্যাঁ দেখো।
Your lordship will please to take the opposition to this.
তোমায় এক্ষুনি দিলাম।
And it এক্ষুনি দেখছিলাম।
হ্যাঁ, দাঁড়াও আমি খুঁজে বার করছি।
Supplementary affidavit to the.
এই যে এটা,
না, এটা হচ্ছে main opposition. এটা হচ্ছে main opposition.
হ্যাঁ ঠিকই বলেছি।
Eight. Your lordship will kindly take, my lord. This is an affidavit which has been affirmed by one Inam Soham Jha.
Well, there are two
Sohan Kumar Jha. Well, it's Sohan Kumar Jha একটাই রয়েছে.
Yes.
And this is, your lordship has got that.
Yes.
This is affirmed, my lord, sometimes in the month of 10th December 2025. Lordship will please to come to paragraph 14. I'm dealing with these letters.
Yes.
My lord, the letter dated 20th May 2019 is alleged to have been issued by the petitioner under its ex-management to the respondent and is alleged to have been signed by one Mr. Vivek Bharadwaj, chief manager of the petitioner. Admittedly, the respondent has failed to disclose how the respondent received such letter. The petitioner's present management had inquired and has found that Vivek Bharadwaj was never authorized to issue any letter relating to legal matters of the petitioner. Then B, no such letter existed in the records taken over by their administrator on 10th October 2021 and did not form part of the records made over to the petitioner's new management pursuant to the order passed by the National Company Law Tribunal, Kolkata bench, upon approval of the resolution plan. Then C,
this has been deleted by a subsequent affidavit.
14C.
14C, and
The
we
opposition
should now read as this.
My lord, this তোমাদের affidavit for affidavit. My lord, this subparagraph C, the Vivek Bharadwaj notice period and last working day 10 June. Well, as a matter of practice policy, well, this particular paragraph has been, well, deleted by another affidavit
On 16 December
on
25.
16 December 2025. There's a mistake on our part, and this particular paragraph has been replaced
No, we should read
replaced by. We should read at
Okay.
Maripede. They've been replaced by the 14C. Your lordship has got that. 14C will read, the last working day of the said Vivek Bharadwaj was June 10, 2019, who in any event was never authorized to or had any power to issue any notice. In fact, the said Vivek Bharadwaj was not even part of the legal team. This is what has been said. And then, my lord, para 16,
the other person.
this is, my lord, kindly come to the main affidavit, para 15 and 16 of that. Then, my lord, I shall take your lordship to the correction which has been made. The para 15 is, the respondent has now sought to disclose the letter dated 29 December addressed to Srimati Bandana Ray. The said letter is neither a joint letter nor addressed to the petitioner. The said letter is also a product of afterthought and has been manufactured at this belated stage only in furtherance of the fraud perpetrated by the respondent. The said letter dated 29 December 2019 has no proof of service and in any event is not a joint appointment letter. There is also no explanation as to how, after 7 months of the purported manufactured letter dated 20th May 2019, such document could have been issued by the respondent when the statutory mandate is 30 days under Section 11 of the Arbitration and Conciliation
This
Act.
remains.
This is all right. Then we'll say para 16. Para 16,
Upon inquiries, it is changed.
yes,
That portion has to be changed.
the first sentence is all right. Another document manufactured is the letter dated 8 December, which again had no record of service, save and except fraudulently obtained acknowledgement by way of alleged hand delivery upon the alleged employee of the petitioner being mobile number so and so. Upon inquiry, this portion, my lord, has been required. Upon inquiry, it has transpired that the said mobile number is one of Mr. Sri Ravi Agarwal, who was again on a notice period under the previous management, whose last working day was April 30, 2021.
This should be changed as this.
And my lord, this is to be changed as, upon inquiry, it has transpired that the mobile number is of Ravi Agarwal, who was again under the previous management and had his last working day as April 30, 2021.
Because notice period we couldn't discover.
So last working day was 30th.
তার জন্য annex করে দিয়েছি ওই
And then, my lord, para 4 of that, the last working days of both Bharadwaj and Ravi Agarwal are based on the information provided by HR department of the petitioner. In this connection, a copy of the email dated 18 September issued by HR to the legal team of the petitioner is annexed here too and marked so and so. My lord, kindly take that annexed here.
Yes, I've checked emails, the date.
Yes. And there, my lord, there is a in box, my lord, it is said
The dates of
the dates of separation had been given 30th April 2021, 10 January. Well, be that as it may, I submit to your lordship
what is this release and separation, Mr.
my lord,
Date of release and date of separation?
কি এগুলো কি মানে বোঝা
It's
separation
first separation, then divorce.
bondage separation.
my lord,
Date
it
of
seems
separation
the
is
date of release.
Prior to, yes. Regarding Shubhajit Das Chaudhary, no difficulty, but
কি বলেছি বল কি মানেটা কি
acha, acha.
Date of release is
Bharadwaj.
Ravindra Agarwal. The date
Different
of
one.
release, date of separation, same. But Vivek Bharadwaj, the date of separation is earlier to date of release.
লাস্ট ওয়ার্কিং ডে আর যদি অ্যাকাউন্ট ক্লোজ করবে টাকা দেওয়া রিলিজটা হয়ে
Yeah.
এনওসি দিয়ে দিলাম লাস্ট ওয়ার্কিং ডে হচ্ছে
Anyway,
Anyway,
June,
whatever. Yes.
June 2029. This is what has been stated. My lord, I will submit to I am submitting to a lordship, my lord, that ultimately the kindly, my lord, in this connection, note our another thing, my lord, that is to be noted is, my lord, see, this is the case that we have made out. And we'll have to see to what extent this entire story made out by the petitioner fits with the case which are depicted from their own documents. And this is what is being said here. Your lordship will kindly come to
এতে মেড দ্যাট স্পেসিফিকই যে ইমেলটা একটাও দেখানি কোভিডের মধ্যে ছিল তার কোনো উত্তর নেই
lordship will kindly come to paragraph 8 of my application, the opposition to this supplementary, or rather to this application. Petitioner state that as per the respondent, the purported meetings of the arbitral proceedings took place during the period of pandemic COVID-19. As per the case now made out in the said application, Your Lordship, sorry. As
I was
per
not
the
finding my pencil.
Yes, as per the
Kalana,
case now made out
Yes.
in the said application, the deponent of the application is the person in charge. Despite the aforesaid allegation, the respondent has failed to produce a single electronic communication relating to conduct of arbitral proceedings, the alleged minutes of the purported sittings, etc. The absence of such documents clearly establish that the documents now sought to be introduced by way of the said application are not only an afterthought but are in furtherance of the fraud perpetrated in making the impugned award. The petitioner further states that from the records of the present proceedings, it will be evident that between October 4, 2021 and August 11, 2023, when the petitioner was custodial legis, the respondent's stand was very clear. The respondent was requesting the administrator to reconcile the demands made. There was no allegation of any arbitral proceeding or any award being passed. In this connection, it is further relevant to state that in relation to the other contract, being contract number 138478, which is not the subject matter of the impugned award, the respondent specifically referred to Lok Adalat proceedings in respect of the said contract. Therefore, it is clear that the respondent made the responses made by the respondent during the aforesaid tenure of the administrator were with full application of mind and consultation of records. The respondent not only accepted the contract in question to be outstanding, but also sought reconciliation of the dues of the administrator. That is 7th October 2020. The petitioner states that the resolution plan approved in respect to the petitioner is the judgment in rem. The resolution plan has been approved on the basis of the list of assets of the petitioner and the loan portfolio of the petitioner. The loan portfolio of the petitioner includes the amounts recoverable in respect of contract number 130853 and 138524. The respondent was aware of CIRP process of the petitioner. The respondent did not object to the inclusion of the dues of the respondent as an asset being receivable of the petitioner in the resolution process. Thus, the approval of the resolution plan having become binding on the respondent cannot subsequently contend that such receivable did not exist on the date of approval of the resolution plan. In this connection, knowledge of the respondent to the aforesaid is evident from the following. 1A. Resolution process was widely publicized pursuant to the order made by National Company Law Tribunal. The administrator was treating the dues as receivable, which is evidence from the demand made by the administrator. Then C. The respondent confirmed its liability and the fact that the dues under the contracts in question were due and payable and therefore amounted to receivables and thus formed the part of the estate of the petitioner, which was subjected to CIRP under insolvency and bankruptcy code. The petitioner states that it is in the above backdrop the documents now further manufactured by the respondent in collusion with the ex-employees have been self-judicially attempted to be brought on record or to be considered. By way of the application, the respondent is seeking leave to then, my lord, I have said what I have placed before your lordship this. তাতে কি বলেছে কিছু বলেছে
বলছে আমি কেন দেখাবো তুমি দেখো this is a specific stand.
My lord, an affidavit in reply has been filed. I am not going to trouble your lordship with this, except this there, my lord. Now, my lord, my lord, kindly come to page 7, paragraph 8 of their reply. Reply is dated. This is thin affidavit. What they are saying here is this, that
7 lines from the bottom.
paragraph 8, after this denied, all denied, in as about 10 lines from the bottom of that page, in as much as the subject matter of the said emails were not the two contracts which were the subject matter of these proceedings, there is no connection between such emails and the present proceeding. It is denied that the respondent has failed to produce a single electronic communication relating to the conduct of the arbitration proceedings, the alleged minutes of the purported sittings, etc. The petitioner has to first dispel all doubts before the onus shifts onto the respondent. The petitioner's case has to stand on its own feet and not the infirmities of the defense of the respondent. It is further denied there, so and so. Now, my lord, I am submitting to your lordship this, that here is an arbitration. Now, my lord, let me sort of, on the factual basis, on the factual aspects of the matter, let me, my lord, clarify my position. Fraud or no fraud? I am saying that there is an award which is been placed before your lordship for confirmation. I am submitting to your lordship that before the award is confirmed, your lordship is entitled to ask the respondent that, look, you are putting forward an award. On what basis has it been made? Where is the statement of claim? Where is the counter statement of facts? Where is it that you have denied, disputed the claim? Where is it, on what basis the arbitrator is saying that submissions were made, minutes were maintained, the citations were given, evidence was taken. Well, it was the evidence that has been produced before the court is supposed to be one of the valuation report of the machine. Now, who gave evidence with regard to the valuation? And that valuation report has been, is supposed to be on the basis of that.
Opposition টা এবার দেখিয়ে দাও।
My lord, your lordship kindly takes that valuation, the so-called valuation
They have
report.
disclosed in the opposition. To the main.
In the main opposition, my lord, the so-called valuation report is at page 33.
In the awarded language. Just go to that award. Award বলেছেন, they have obtained. দেখো।
My lord, this is kindly come to page 32 of the afternoon opposition.
Yes.
Address to say equipment. Surrender of one number of each stacker in respect of the above mentioned agreement and undertaking during arbitration proceedings. During arbitration proceedings, kindly note this. This is to inform you, in respect of the above mentioned agreement entered into by and between myself and myself and your good office, wherein in respect of the asset mentioned above, we are supposed to make handover as asset, the asset of above agreement, out of our own will, without any force, coercion, and or undue influence, has surrendered the above one asset more fully described in Annexure A, attached to the letter from Concord Yard at Hyderabad, Telangana, in so and so, on 8th March 2020, in respect of the above mentioned agreement. The valuation report of so and so having license number so and so is for rupees 75 lakhs, attached along with your yard inventory report dated 9th March 2020. And there, my lord, this is supposed to be a valuation report dated 8th March 2020.
Who did the valuation? According to this, they have done the valuation.
Well, kindly see the valuation report of equipment, 8th March 2020, date of inspection, etc., registered owner, body, still, then approximate market value. Just like this, one sentence, approximate market value based on above and on the basis of my professional experience is rupees 75 lakhs only. I declare the above report now. Then, my lord, kindly see the annexure. This is very interesting. Kindly look at the annexure. What is there in the machine which was valued? 75 lakhs. Kindly see. Remarks, if any, kindly come to the remarks. First of all, my lord, what is not available? Registration certificate, insurance certificate, tax token, permit, good road challan, nothing is available. And then remarks is no key, no batteries, no tires, no fuel cabin, no glass, cabin glass is damaged, welding noticed in boom and spreader, air something damaged, hydraulic oil leaks noticed from so and so, discs 5 numbers, 4 numbers, hubbing and lifting, cylinders 2 numbers, boom, spreaders, chassis, total so and so, engine asset is in dismantle and non-starting condition. Came to the yard by trailers. Well, I don't know what is there.
Poor machine.
75 lakhs of rupees.
আরে এটা দেখো,
In my, and my lord, what is said here is this, that
they got it
on the basis of my professional experience, 75 lakhs. This machine without battery, without tire, without fuel, without everything.
award knows that the claimant has got the machine valued.
And my lord,
The award notes
and the award is noting, my lord, this particular valuation,
has
the
been-
claimant has got the machine valued through approved valuer, who has valued the machine at
they
75
have
lakhs.
got it valued.
And this is in paragraph 13
13,
of the award.
13. Have you, এই যে,
এই যে এবার দেখো
My lord, 8th March 2020, and the date is very significant also.
Hmm.
The sitting has started in the month of January. So 18th of March 2020, the valuation has been made of this, and this sheet of paper had been tendered, and on the basis of which an award has been passed.
এই দেখো এখানে registered owner road wing, they have got it valued.
আরে সে তো লেখাই রয়েছে, তো
কোথায়?
অ্যাওয়ার্ডেই লেখা রয়েছে।
না,
It
না,
has
না,
got it valued.
award it লেখা রয়েছে, Clement has got it valued. So they are producing.
So, my lord, kindly see.
লেখা আছে, they have got it valued. না না, এটা তো দেখেছি তো, এখানে কোথায় লেখা আছে?
My lord, it is not written anywhere that the claimant has got it valued. Valuation report, so and so, date of inspection. Let me see. Let me read it.
একটা আছে
carefully.
যে at their
Approximate market
premises.
value, I declare the prejudice to a circumstance. Who got it valued, my lord? That also we.
দেখো, এখানে আছে। এই দেখো, এই
না, name of the
নেম,
ওটা কি ছিল? নেম ওটা, নেম অফ দ্য কোম্পানি। উল্টো পাল্টা বলে লাভ নেই।
না না, নেম অফ দ্য কোম্পানি, আই নো,
তার মানে নেম অফ the person who is producing.
obviously.
My lord, there is not a whisper about, my lord, the claimant in this so-called valuation. And my lord, it is said in the award. It is said in the award that the claimant has got it valued. Where did it come from? I mean,
It was with them. The machine was with them.
yes.
At page 34, from whom asset seized is customer self handover. But that may be, even if you. So they got the asset from respondent. Customer self handover. This is, so customer means if the customer is of the valuer,
Yes.
then it's a respondent who is the customer.
Yes, that's correct.
So therefore the respondent appointed him. By that
Respondent
analogy,
must have appointed
may
him.
just be, yes.
It was, the
you
asset
see
was
the
lying at Hyderabad.
Middle of page
Korea.
34, from whom asset seized, he does not say road wings or owner or something. He says customer self handover. So road wings must be the customer of that valuer.
And my lord,
Your argument.
and yes, and my lord, my submission is there is no mention of, my lord, the petitioner in it is entire document. So my lord, there cannot be, I mean, lord, one cannot infer from this document that it has been valued by the claimant. Well, I would like to know one thing, that if evidence had been laid, who laid evidence? Well, Lord, kindly see the award is mentioning a lot of things: statement of claim, documents, evidence, and, my lord, citing of decisions, cases, case law. I'm sure, my lord, it could not have been done, my lord, by the respective clients. And during COVID period, which counsel will go and, my lord, appear in the matter?
Yes, I got it. হ্যাঁ,
Well, I do not know.
page 32, এখানে একটু পড়ো এটা। এই ওই যে বলো, এই যে page 32,
Page 32 of.
হ্যাঁ। এই যে এই যে এই ডকুমেন্টটা।
No. Chotfot করো না।
হুম।
Need to know.
Page 32.
Yes, they say they road wing says they handed over the asset
No.
Your lordship, the Road Wings International is writing a letter
to you.
to, my lord, the
Eight
say
to
equipment,
Hmm.
that out of our own will, without any force, coercion, and undue, I have placed this letter,
হ্যাঁ, তারপরেরটা।
has surrendered the above one number of asset more fully described in Annexure A attached to the letter from Concord Yard
Yeah,
of Hyderabad,
Yes.
Telangana,
Huh.
to your authorized Hyderabad NAC Yard
ব্যাস।
at Hyderabad,
Yeah.
Telangana,
Yeah.
on 8/3/2020, in respect of the above mentioned agreement.
এই-
The valuation
এই-
report of CM so and so
এইটুকুনি।
having licenses is our
এইটা 83 এবার
and
পরের পাতায় দেখো where
and
the
that-
valuation was
and that
done.
is the
Page 33 তে দেখো the address where it was inspection was done, Hyderabad at Concordia.
Concord Yard.
That is their premises.
No, there is no doubt that it was their premises because the machine was with them.
Yes,
হ্যাঁ,
বলো।
this says it was handed over on 8th March
2020 from Concord Yard, their possession, to whatever, another Hyderabad. This is what, on 8th, right? Now come to the document at 33. Where was the valuation done?
Concord.
Concord. When, my lord? On 8th. And the award says on 7th, Clement did the valuation. 7th, the valuation was done.
Award says it was done on 7th.
7th, yes. It says
No.
13, just a minute.
Paragraph
Yes.
13,
Oh,
1-3.
yes, sorry. The respondent has surrendered it on 8th March, I'm sorry. Claimant has got the valuation through approved valuer.
That is what we are saying. If the
Yes.
claimant had to have the valuation done,
Yeah.
then claimant had to be the customer of the so-called customer of the valuer.
Right, Miller.
But valuer says at page 34, asset seized from whom? Customer self-handover.
At
That road,
Concord.
Concord,
At Concord.
Concord is an admitted position.
No, and he says we handed
Concord
it.
to somewhere else in Hyderabad.
No, we handed it over from Concord to their another place in Hyderabad. The valuation is done by the valuer in Concord, which is their premises. That is what I wanted to tell you, Lordship. Forget it. That is something else.
My lord, on the top of the page, it is written Shrey Equipment Finance Limited. It is Shrey's document,
Thank you.
their inventory list. I am the hirer.
my lord, so this now, my lord, I have covered the evidence part of it, the entirety of the evidence part of it. My submission is this is my submission in winding up on all this. My lord, there are two awards that sought to be put forward before Lordship. One is dated 17 September, the other is dated 21st September, both of 2020, in respect of two contracts. Now, my lord, these awards were not served upon us, admittedly. We did not get any copy of the award from the arbitrator. Arbitrator, when we wrote to her, she refused to give it. You pay the money, then only I shall give you. What happened is this, I get a copy of the award from where? From the affidavit in reply filed by the respondent before the NCLT. For the first time, I came to know of it. And when I came to know of it, I immediately rushed to the court, and within, my lord, 90 days, I made the application for setting aside. In fact, my lord, setting aside what? I am submitting to your lordship, there is no award at all. There is no award. Because if had there been an award, the reaction of the award holder would have been totally different in various my lord, in the documents. Your lordship will please to, in this connection, kindly take, my lord, section 34. I am very strongly relying upon section 34, subsection 2A. My lord, the significant difference in language of section 2, subsection 2 and subsection 2A. Section 2, subsection 2 says, an arbitral award may be set aside by the court only if what? The party making the application establishes on the basis of the records of the arbitral tribunal that 1, 2, 3, 4, 5.
2B and 2 small b, 34, 2 small b and 2 capital A, both say if the court finds.
Yes,
If the court
if the court
Yes.
finds. That will be my submission to your lordship, that if the court finds, then I do not have to, then, my lord, I do not have to rely upon subsection 2, any of the subsections of
2A এটাতে বলো মানে 2A তে হচ্ছে পার্টি মেকিং দ্য
না
অ্যাপ্লিকেশন
সেটা তো জজ সাহেব বললেন
You have not come in under any of 2A.
in
condition.
fact, my lord, I have kindly come to subsection 5, Roman 5. subsection
Composition of the
A5. The composition of the arbitral tribunal or the arbitral procedure was not in accordance with the agreement of the parties, unless such agreement was in conflict with the provisions of this part, from which the parties cannot derogate, or failing such agreement was not in accordance with this part. I say, my lord, it was not in accordance with this part, and that what I have adverted to in my petition. But apart from it, I am submitting to your lordship that subsection 2 capital A, an arbitral award arising from out of arbitration other than international commercial arbitration may also be set aside by the court if the court finds that the award is vitiated by patent illegality appearing on the face of the award, provided that an award shall not be set aside merely on the ground of so and so. So, my lord, I am submitting to your lordship that there's a vitiated by patent illegality appearing on the face of the award, because, my lord, I submit that insofar as the appointment procedure is concerned, it is my lord, it is inconsistent with, my lord, what has been stated by the respondent. Number two, I am saying there had been no appointment at all. I did not participate in it. One of the parties against whom, my lord, the award had come, he is coming before your lordship and putting before your lordship cogent evidence that there could not have been an award. Because, my lord, if there had been an award, the correspondence between the parties subsequently would have been totally different. If it is inconsistent with that, the question of probability of having an award becomes very important. During COVID period, entirety of during the COVID period, the arbitration sittings have been held. We do not know where they have been held. Even though so many pleadings have been filed before your lordship, nothing has been told by the party who is, my lord, putting the award forward before your lordship. Nothing has been said as to how it was held, where it was held, who are the persons who appeared, whether there are minutes kept or not. Throughout, my lord, I find that it has been recorded that the claimant had filed its power of attorney. Claimant has filed its statement of claim. Claimant has laid evidence. Well, nothing has been said about respondent. Even the valuation report on the basis of which, my lord, the award has been, my lord, what has been considered, that valuation report, my lord, the onus has been put upon us. At the instance of the claimant, it was done. Well, I fail to understand, I fail to appreciate. In the entire award, well, subject to correction by my learned friend, there is nothing which has been said as to what the respondent contended. And at least, my lord, we should be favored with copies of the pleadings. What case, my lord, I came forward with, what case they come forward with, what was the claim, what was the defense, what was the counterclaim, whether there was any allegation with regard to the valuation report which was made, the valuation, is there any my lord, something should be there before your lordship to enable your lordship to come to the conclusion. Well,
small b তে হচ্ছে court finds in conflict with public policy.
subsection B of section 34(2) is also the court finds.
Court
About
finds.
2A is also
That is what we said. That
Yes, sir.
B and 2 capital A court finds.
the court finds.
Public policy for
And the court find, my lord, in this particular case, my lord, in this particular case, if your lordship takes, my lord,
Also taking fraud here.
yes.
You have specially pleaded there was no award and
I pleaded for fraud.
affected by fraud.
Yes.
Not induced by, but affected. Induced is
Induced or affected by fraud or corruption.
এই যে উপরটা পড়ো explanation 1টা এই না সরি আইটা বি স্মল আই
The arbitral award is in conflict with the public policy of India.
includes everything. The court will have to
also basic notions of morality and justice.
yes public policy. That's the definition.
My lord, what is the public policy, my lord? Is that both parties should be heard before an award is passed, before a judgment is delivered. My lord, the arbitrator definitely, my lord, must have given notice.
But you cannot take that point. That could be taken by the respondent. You are heard as per the award.
I've been heard. No.
Only you are
My
heard.
lord,
You
is
can take that
absolute.
this point.
There is nothing to say, my lord, that the respondent. Well, I was surprised to find that an award in which, my lord, only the claimant has been mentioned, respondent is not there at all.
There is an omission in section 34 with due respect. I mean, Mr. Mitra, this is too large for me to say. But this does not include all these provisions contemplate challenge to an award which is there. An award is there. But no provision for seeking a declaration that there is no award in the eye of law. Nullity. Not nullity. No award. So otherwise, strictly speaking, you should have gone before a civil court and sought a declaration that there is no award. This document does not exist in the eye of law. Because the Limitation Act provisions also come in, and if you want to avoid a document, any document, this is a document. You say there is no document in the eye of.
I have thought about that.
So that is missing within the four corners of section 34. But we can read that into public policy and all this.
I respectfully submit to your
There should be a
lordship this.
specific provision in this in section 34 that a declaration that the court can be approached for a declaration that there is no award at all. No award was passed at all. You said no award was passed, and these are your ancillary points.
Your lordship is perfectly right.
So you can look at that under, say, maybe 2A or
Some
public policy.
some kind slightly
Affected by
stretching.
fraud also maybe.
Yes,
there was
slightly
no award.
stretching. So therefore, my lord, I will submit. Only thing is this: if your lordship,
If I may, that what your lordship is saying, it was covered by Supreme Court previously, but that has been negated. You can never basically challenge, file a suit. All those old law that has been set to rest.
Exactly, but there's but then the statute should give a provision for that.
There is no
No provision,
and consciously
can't
not
find it.
given, interpreted because we have not given a provision. Therefore, you have to, like public policy, and you have to do it. Well, I forget the judgment reference.
After Sangyang. After Sangyang.
after
No, it's before the
In this
or before all things. Justice Aftab Alam's judgment, presided over by Justice Aftab.
Anyway, we'll try.
lordship can give me. This is exactly what I told the junior. I said that this is no
Affected fraud can broadly count.
there should be a declaration that there is no. There should be a declaration that there is no.
Section
No award declaration, no provision is there. So affected by fraud.
Exactly period.
prima facie, you have
Because your case is 31, 1 is not, I mean, does not come into play because there was no award in the eye of law.
prima facie, you have to come that there is fraud. That is the peculiarity because court will find.
No, court court can file from the circumstantial
That
evidence
is
also.
prima facie.
But then order 6 rule for that those regard don't come. Don't come.
There is a judgment.
My lord, quite apart from the judgment and things like that, looking at the my lord, the section itself.
Yes, section
my
is
lord-
very clear.
If my lord, the award was induced or affected by fraud, then my lord, award becomes no award.
In my limited understanding, Mr. Mitra, if the fraud was intra-proceeding, then the award was induced by that fraud. Some fraudulent document was produced or something fraud practiced during the proceedings. Then award is induced by this fraud. But here, award is affected by fraud. It's a fraud. The award itself is a fraudulent document.
Well, I was just wondering what is
So
the
not induced, but award is directly affected. by fraud.
affected. Well, this is exactly the point that I am.
If our conscience is satisfied, we'll find a way.
Your lordship. Well, I am just thinking of this since it has fallen from lordship. In fact, last night I was just looking into the section.
Yes.
The making of the award was induced or affected by fraud. Affected is a very wide term.
Affected is direct.
Yeah.
Fraud award is affected by fraud. The award is fraudulent, that is also affected by fraud. But induced is probably one of the parties put in some document on the basis of which there is an indirectness about induced. I induce you to do something and you are affected by something. Maybe whatever.
Well,
not go into this
submit to your
academic.
lordship, it is wide enough.
It's a spiral.
Well, if it is fraud,
Yes.
then
Either way.
then my lord, the award goes altogether. My lord, you said award becomes non-est.
Suppose the previous section 340 scenario. Then the award is induced by fraud. Because the fraudulent document is produced. On the basis of that, the arbitrator is induced to pass this award.
But
Here fraud affects
affects
the,
it.
according to your case.
Affecting is a much wider concept,
yes,
and I
yes.
am submitting to your lordship, my lord. If that is so, this section 34
Is
takes
sufficient.
note of what is falling from your lordship. Let
That
me
is
put it
sufficient.
that way.
Yes.
Let me put it that way.
Also morality.
আচ্ছা আর কিছু দেবে আছে কোন
Morality justice.
moral
That is one of the
Morality, justice. Yes.
bribes. There's case law on that.
Yes. But there's that judgment of Justice Nariman while discussing, it was held that in the context of arbitration, it was held that morality has largely been discussed by Indian courts in other contexts, matrimonial and other contexts,
Yes.
and that was brought in while discussing this morality.
Yes.
Anyway, morality is ethics. Otherwise, morality is very vague.
but fraud is immoral.
Fraud is
Let
very,
me put it that
very
way.
patent. Yes.
my lord উজুর জাজমেন্ট সাইড করার দরকার আছে জাজ সাহেব তো বলছেন যে it was induced the difference between subsection 2 and subsection 2A. Well, I just refer your lordship to the two decisions, my lord. 2010 4th Supreme Court cases 518 and
না ওরা আর্গু করে তারপর দেবে তুমি একটু ফট করে
না এটা দিয়ে দাও না
হ্যাঁ
2010 4th Supreme Court cases 518 and 2022 2 Supreme Court cases 275.
এই দুটোই তো
The difference between section 2 and section 1 subsection 1 and
N4 SCC page 518.
518 is 10 4th Supreme Court cases.
Yes, and the other one
At 22 2 Supreme Court cases 275.
প্যারাগ্রাফ
27.
5.
Thank you. What are the names of the parties? Just the
Well, I
first
shall give you a lordship. One is the name is I always forget about it. Yes, I shall give you a lordship immediately.
one take written notes of arguments from you ultimately. So
Yes.
give written notes so you can mention.
আরে প্যারাগ্রাফ গুলো লেখা আছে
Formally cite because the other side should be put on notice.
One is Sal Ujjog.
Sal, yes.
Yes. And the other is one Hindustan Construction.
Oh, that's right.
Hindustan Construction is a 2010 4
Yes,
and 2022 is Sal.
Sal will do.
Ito. Well, these are my restricted submissions.
এটা দেবে নাকি
সাইড করেছেন
হ্যাঁ করতে
Any particular paragraph you want to
Yes,
you can
paragraph.
just give them paragraph numbers, Mr. Bhutta.
Well, I shall hand up to your lordship one of the copies of this also.
এটা উচ্চিত নোটটা
প্যারাগ্রাফ ব্যাপার
First is let me give 2000.
Sal and Sangyang are cited in every other case.
Yes,
And
well,
associated is also brought to explain away because Sangyang has referred to paragraphs of associated, and so we have to go through Sangyang and associate more than our
lordship.
whatever.
Well, I am formally placing it before lordship, but these have been placed so many times before lordship
You
that
can refer to particular paragraphs, Mr. Mitra, if you want.
at Delhi
or
copy দিয়ে
with-
দাও that সবগুলো refer করে রয়েছে। Well,
Just
Hindustan.
put in one line in your written notes of arguments as to what proposition you are citing it for. Very good.
Then, well, I can hand up to your lordship, well, the copies of the judgment.
Copies you can hand up now, and
Yes.
in written notes, we not
Delhi
incorporate
High
this
Court
to-
judgment. Yeah. Delhi division bench, my lord, is very detailed judgment
Yes.
referring to both these judgments.
রিভার্স এমপ্লয়িজটা
Which one?
My reference is 2023 SCC online Delhi 1608, which is reported in arbitration law report 2023 volume 2 arbitration law report 107.
SCC online will be
Yes,
better for me. What is the name of the petition?
Well, it's will
It's
you
a
get the paragraph.
Devas employees, Mauritius versus
Devas,
Antrix.
Devas.
Yes, Devas.
Well, para 108 109 110 113.
দাঁড়া আমি লিখে দিচ্ছি অত করে ওরকম করে বলো না Well, may I write on your lordship's copy
Please do.
the paragraph at
That
the
will be
top?
very
Now
helpful.
for them we must tell them.
No, ওরা খুঁজে নিক সবকিছু
Acha, we will give them Mr. Bose, you can.
Yes,
110.
110 113
I-
114, then 120 to 123, then 124 small d and small g. Well, this is the main and has 2020.
Basically 106 to 110 has been written here. Has been written here.
106 to 110 the entire the proposition has been formulated.
120 up to 124. My lord, has your lordship got 2022 2 SCC?
হ্যাঁ, বলেছি। 2SCC 275, I copied it.
Yes.
2022 2 SCC 275 para
I
24. But that is not a case of fraud and corruption, but that the court will find out. On the proposition, my lord,
Yes, definitely.
that distinction between it. চল ও চলো মানে দেখি
Yes.
না ও আচ্ছা ও আমরা সাপ্লিমেন্টারি ডকুমেন্টসে আরো ছিল we have not dealt with it because
But no, why should I not? Because since they have annexed it, why not? Well, kindly, my lord, give me 1 second.
Yes.
I'm sorry, I should have placed it before lordship. Kindly, my lord, take the supplementary affidavit which is annexed to their application. Well, this is very interesting. Well, yeah, thank you, because I forgot to mention. তোমাদের এই কপিগুলো এত বাজে, তোমার কি বলবো?
ইয়ে কোথায় রে শঙ্কর স্যার
Lordship will kindly come to. Your lordship has got the supplementary. Kindly,
Yes.
my lord, I just quickly,
The thin one.
Yes, this is the
application
My lord,
GA1
GA1. In GA1, my lord,
Yes.
what they have done is this, the
The
supplementary,
supplemented affidavit in GA1.
no, supplementary.
GA1
তুমি দাঁড়াও আমি
ওই তোমরা সবাই মিলে যদি একসঙ্গে কথা বলে তাহলে কি করা হবে?
No, Mr. Mitra, you just tell me. What are you, which,
This is the kindly take the respondent's application to bring additional.
yes.
Now, there, after the documents which have been cited, they have annexed, enclosed with this application, they have, what they have done is they have annexed the copy of the supplementary affidavit which they wanted to file before.
Yes.
Now, that is at page 14. Is it here?
Yes, yes.
Page 14,
Yes.
the supplementary affidavit. Now, with them, with that, my lord, they have annexed certain documents.
Doctor's prescription for Mr. Rai. as
Yes,
Adip Rai.
kindly ignore them and for the time being.
Huh.
And then, my lord, kindly come to page 27. No, this is what I've already placed page 27. Kindly come to page 28.
Yes.
Road Wings Internet, they are themselves disclosing this.
Huh.
18 January 2024. Important thing is who has signed it. Mr. A.K. Roy, the gentleman who was ill.
and the date
18 January 2024. And what
Yes.
is the right? বসো না তুমি। বকুনি না দিলে তোমাদের হয় না। Lordship, kindly take this judgment. This letter, administrator addressed to.
Yes.
The contract numbers of the election so and so. Kindly see, my lord, these two contract numbers are also there. 130853
Yes.
and the other one was 478. These contracts are all closed and charge in ROC civil created by SREI needs to be deleted. We once pray your good self that we are unable to conduct any business and request your help in the matter. No mention. Mr. Roy is, my lord, not mentioning here any award.
Mr. Rai is not?
Not mentioning any award. He is the man who was in charge of the arbitration. That's what they have said in their application.
So why do they annex this? For what purpose do they annex this?
They, my lord, what they did was they, by mistake, I think they annexed it, their supplementary affidavit. But they did not, my lord, when they filed the application for additional evidence, they did not include that.
Oh, this came as an annexure to the supplement.
Annexed to the supplementary affidavit, which they have annexed.
আর অপোজিশন
Then, my lord, kindly come to.
না অপোজিশনটা ফাইল করেছে জানুয়ারি এন্ডে when the administrator had gone
Then, my lord, page 29, 17 January 2024.
just before the opposition is
Here, Mr. A.K. Roy is writing on 17 January. And I don't understand this really. On the 18 January 2024, he is writing this. On 24th, 17 January, at page 30, my lord, kindly see. We have given several reminders. First paragraph, last sentence. We have given several reminders in this regard to yourselves, but to no effect. Further, there have been arbitration awards to which in which contract number so and so has already been adjudicated. but the charge still remains in the ROC sites and civil. Well, this did not come at all in the affidavit in opposition, this letter.
hand delivered. আগের পাতা কিছু, আবার এটা hand delivered.
And this is hand delivery. This letter was not a part of the affidavit in opposition. This is an important letter according to them.
28 জানুয়ারি কয়েকদিন বাদেই অপোজিশনে ওই যে অ্যাওয়ার্ডটা দিচ্ছে ডেটটাকে দেখে নাও ডেট গুলো দেখে
17 January.
আর অপোজিশনে এনসিএলটি তে 26 তারিখে করছে দে আর ক্রিয়েটিং দ্য কেস
Not annexed to which opposition?
And this is not annexed to this so-called award was annexed for the first time in the affidavit in reply, and that was in the month of 24th of January. The 17th,
these are
17 January. That was 24th January 2024.
after the
From which manner I came to know.
after the administrator October August 23
If this letter had been given to us, then my lord, we would have the first thing one is expected to do is to ask for the award. And then he says that we are facing problems with the award.
administrator চলে
Very
গেছে
important. Date টা দেখুন।
Then, my lord, kindly come to page 31. This is more interesting. My lord, it is becoming curiouser and curiouser. Kindly come to page 31.
Yes.
This they have abandoned.
Benjamin is being unbuttoned.
Absolutely. Kindly see this. 20th September 2020. 20th September 2020.
Yes.
17th September 1, 21st September another. Award. And this letter is being written by authorized signatory of Road Wings. And he is writing to the managing director Srei. You are requested to issue NOC for contract number so and so, and these numbers are there. 130853 and 138524, which has already been closed. You are requested to take necessary steps to make compliance with the ROC formalities, removal of charge, etc. And then they have so and so liability. No mention of any arbitration proceeding, no mention of award, nothing, absolutely.
Sunday.
One award has already been made, 17 September.
Only in at page 30 it's mentioned.
no yes
Yes, only in
Ju-
page
just
30.
prior to তখন অ্যাডমিনিস্ট্রেটর চলে গেছে just prior to the opposition filing opposition
My lord, one thing, page 31, we have checked. That is a Sunday,
20th September.
20th September 2020. My lord, now that is a Sunday.
And then, my lord, the last document in this page 32, 2nd December 2024, a complaint is being made to the Ombudsman, Reserve Bank of India, by Road Wings.
This is when
No mention in this entire letter, there is no mention of any award. কোথায় আছে?
This is post section 34. This is
oh
section
this is
34.
post section
This is post 34.
oh yeah.
Filed in April 24.
This is post 34
কোথায় awardের কথা রয়েছে?
না এখানে অ্যাওয়ার্ডের কথা নেই
আমি unless of course I have missed it. কোথাও হতে পারে?
ওখানে already ছিল. So please
they're mentioning about the NCLT has been
stand up. This is post 34. Right?
This letter has been written to the Ombudsman. No mention. The Ombudsman is not supposed to know of any award. And there is no mention of the award. Why do you say the award has been mentioned here?
NCLT proceeding
NCLT proceedings is there. But what is the mention of the award? You are complaining that the entire thing has been settled. And there is no claim. Will they not rely upon the award writing to a third party? Saying that, look, this particular one thing has been gone before the Lok Adalat settled, the other two have gone before the arbitrator and has settled. And there is no mention of that. That is my complaint. That is my grievance. So, my lord, I say that this is this entire award and entire the proceeding is shrouded in mystery. We do not know ultimately what happened, who did it, how it happened. And my lord, this on the basis of this, my lord, can an award be sustained? I am requesting your lordship because if this award remains, so long as this award remains, my lord, they will be, my lord,
Will be
denying.
barred by the principle of legitimate. I mean, you cannot raise that claim.
I will have to raise this issue somewhere. Well, these are my respectful submissions.
Would you like to start today?
We'll continue.
You are led by Mr. Bachar.
Yes, ma'am.
You are for road wings.
He won't respond.
Well, heard learned senior counsel appearing for the petitioner in APCOM 529 of 2024, puts up for arguments of the respondent, let the matter stand adjourned till February 6, 2026. 6th February. Next. কিন্তু খুব সাবধানে দেখো, মোটামুটি সাজানোই আছে। হ্যাঁ, আজকের নোটিশটা হলো আছে। ফর্মালি ডাকো তো।
Number 5 and 6. I appear for the respondent.
Yes. You were arguing on the last week.
Milord, we were continuing arguments on the last occasion. May I, Milord, pray for a passover? Milord, I'm led by Mr. Bag and
Yes.
grateful.
It's not recorded in order.
I appeared with the cases, I'm being late, Mr. Chindra.
We are just passing it over, not recording.
I'm grateful. Number 7.
Pass over.
Number 8.
It also I'll be asking for a passover, but affidavits.
Oh, the
I'll file it when the
technical.
matter is taken up.
Pardon?
Well, affidavits are, but I think, Milord, I'll file it
On the
when-
next.
when
Not
the matter is
recording
taken
anything, just passing it over.
Yes.
এতে টেকনিকে পড়ো ইয়ে দেখ।
9 not to come for the appellant and I'm led by senior advocate.
Pass over. Pass over means not today. Okay, this is a port appellate. Issue. Division bench.
My lord. Pensioning for inclusion.
Single bench.
No.
Regular bench. This bench. Yes, yes, absolutely.
My lord.
If this bench any matter is there, please bench. This bench.
This bench.
Please. Yes. Fight with the
I appear for the petition. They have not yet complied with the orders, Lordship. The review was dismissed on the last occasion, and Lordship 4 weeks time was given to them to comply or to challenge in higher forum.
Lordship, it has been challenged in the higher forum, and I have received a letter from my advocate on record.
Right.
That there were certain defects have been cured.
Lordship, I have the status from Supreme Court website as of today morning.
Lordship, I cannot.
All the defect, there are 16 defects which is still lying.
Lordship, I cannot go on.
Lordship, since they can refund the amount and challenge the order.
Lordship,
They are not
then it
refunding
will.
the amount since 30th July, Lordship.
Lordship, within 2 weeks it will be listed. That's what the instruction. That's the instruction.
So this is the current status. There are 16 defects. I got this copy. Lordship, kindly take the second page onwards. All these defects are there, still there.
This is my instruction,
second,
Lordship. I cannot go beyond that. My
learned counsel appearing for the alleged contemner submits that a special leave petition has been preferred before the Honorable Supreme Court against the parent order from which the present contempt application arises. Who's the next para? Letter in that regard is handed over in court today, which is kept on record. Learned counsel further submits that there were several defects in the matter which have in the meantime been cured. Next para, it is also submitted that it is expected that the special leave petition shall be taken up before the Honorable Supreme Court within about a fortnight from date. Next para, learned counsel appearing for the petitioners submits that there is no bar in the alleged contemner complying with the parent order and pursuing their challenge in the SLP. Because of that apart, an information slip of the Honorable Supreme Court as of today, is handed over in court today, indicating that several defects are still there in the SLP. Next para, be that as it may, for the sake of judicial propriety, in order to give an opportunity to the alleged contemner to test the parent order in appeal, let the contempt application stand adjourned till. We'll give them 3 weeks. We'll give the Supreme Court 3 weeks. So no, for the defects to be cured. So we'll give you 3 weeks. You said within a fortnight you anticipate. We'll give you 3 weeks.
Much obliged.
27 February next listed on February 20. We are keeping it on 27 because there are other matters. February 27, 2026.
Get Lordship 27. Lordship.
February 27th. Next date. Yes. Huh? We further note that in the order dated December 8, 2025, the number of the contempt application had erroneously been mentioned as CPAN 71 of 2024. Let the same, in the caption of the said order be deemed to stand corrected to read CPAN 71 of 2025. Thank you, sir. Reading to the
my review.
Half a second, Mr. Bondawad. What is the defect in the review application? There is a defect in it.
Defect, my lord, I have
Just check up.
the affidavit is serving.
File it. It says barred by limitation.
But I have filed a section 5.
Section 5 is there. Classification of the appeal furnished in words is erroneous. You may want to review from maybe original order. You check up with the department. Yes, sir, we are granting you. প্রথমে একটা order.
The delay is 127 days.
The report says 103 days. We will first give you that liberty. Liberty is given to the learned advocate on record for the review applicant to carry out the necessary rectification in the memorandum of review as per the additional stamp reporter's report dated December 9, 2025 during the course of the day. Correct. Now the condonation application is now taken up for hearing. Condonation application condonation application ডাকুন পরেরটা তাড়াতাড়ি দেখ অন্য ম্যাটারগুলো ওয়েট করে আছে
No notes.
দেখো ওগুলো ট্যাগ করো ওই গট টু হবে আছে
Can take my.
But paragraph 6 is my explanation. There's a delay of 127 days. And Malad also because of Malad's
the state
determination, Malad has created a problem.
But I hope my learned friend will not
In person.
I will not stand in the way.
not stand in the way.
But the review is also Malad not of Malad.
We'll just pass it on. Since we do not find the original can 1 of 2025, comma, this is can 1, the section 5?
My lord.
কোনোটাই তো নেই can 2 নেই anyway
There's only one concern.
comma we treat the copies of the said application handed over by counsel today in court as the originals for the time being. However, comma, the office shall trace out the original application and tag it in the main file at the earliest. The next para, upon hearing learned counsel for the parties, comma, we find sufficient explanation for the delay of about the delay has been furnished, comma, inasmuch as there were procedural wrangles in the movement of the files relating to the review application. Next para. Hence, can such as do you know which one is can 1 and which one is 2? None is with us. Have you got the filing slip is there with you?
Well, I'm indicating. Malad.
Otherwise,
We are looking at the case status, Malad. I'm just indicating.
Very just we are passing the order.
Filing slipটা সামনে আছে।
এখানে শুধু রিভিউ নাম্বার লেখা আছে can a review to filing system.
Can accordingly can 1 of 2025 we are putting it as can 1. If it's different, then tell us. Can 1 of 2025 is allowed on contest? We are making it on contest, comma, thereby condoning the delay in filing RVW 23 of 2025. What is the review about? We'll dispose of the review as well as the mail.
Yes, Malad, I'll try to restrict it to the memo, Malad, without taking it to the stay application,
Right,
Malad.
right.
Malad, Malad, I'll start by saying I'm a bit novice in the GST Act, Malad. But kindly,
Who are you talking about?
kindly do not ask me any technical questions, Malad.
Your learned friend is
I have taken up the brief, Malad, knowing that I will argue the review matter.
only your learned friend is the expert in this field. Here.
So, Malad, your lordship had passed an order by setting aside the appellate authority's order, which was order under section 107, which was an order, but stemming out of a show cause notice under section 75 of the GST Act. Now, Malad, your lordship, while allowing the appeal, your lordship has held that the delay was directory, the limitation was directory,
Right.
and has held that the order was uploaded in an additional notices tab, therefore they could not view it. And also, your lordship has dealt with the natural justice part. Malad, I am not agreed by any of it, Malad. It's not a appeal in disguise. Your lordship will kindly take paragraph 80 of the order.
Yes, 80.
Your lordship has held, Malad, I'm reading, Malad, for continuity. Accordingly, Matt so-and-so is allowed on contest, thereby setting aside the impugned order dated so-and-so, as well as reversing the order of the appellate authority dated April 23, 2025, and the order passed by the proper officer in respect of the assessment with regard to the appellate firm, it is made clear that nothing in this order shall preclude the respondent authorities from issuing a fresh notice under 73(1) of the West Bengal Goods and Service Taxes Act 2017 and from proceeding afresh on the basis of the same upon due compliance of the relevant provisions of the Act and in accordance with law. Now, this particular part of the sentence, what it restricts me, section 75 gives the timeline within which it can be done. As far as if I go by the section per se, that timeline is over. Therefore, in all the cases, and the cases cited by my learned friend also when the appeal was heard, in all the matters of other high courts, the courts have held that upon due compliance, within say 4 weeks, 2 months, 3 months, then that timeline which is in section 75 is reopened. Therefore, if your logic kindly takes, I have given the timelines when it has expired, ground 8 and ground 9 also. 9 is basically law point, ground 8. Kindly see ground 8. At the bottom, your lordship will find where it ends, and to proceed afresh on the basis of the same, as the case is for the period 2019-2020, as per section 73 of the Goods and Service Taxes Act 2017, the time limit for issuing notice expired on 31st May 2024. And the time limit for raising the demand expired on 31st August 2024. Therefore, when your lordship says that you act in terms of the provision, I am debarred. Therefore, kindly open that extent and add the line whatever time your lordship feels reasonable within 1 month, 2 months, 3 months. Kindly give me that time, my lord. I have checked the judgments which were cited by my learned friend before lordship. Even those judgments have that timeline. Otherwise, my lord, your liberty given to me is closed by operation of the law. What do you say?
Well, that's one thing. They are relying on section 75(3) to contend that there is a provision under the GST Act which says that any order passed in pursuance to an appellate order or a court of law, there shall be a time limit of 3 years to complete that. Now, this provision, Your Honor, was my lords was not cited at the time when they had made this argument, and my lords had dealt with each and every aspect. In this case, my lords had came to a finding that the show cause notice was defective because it was violative of section 73(9) as well as section 75(4), elaborately dealt with in paras.
That was about the previous show cause notice.
265, Your Honor.
That has been set aside.
Yes.
What about the fresh one?
My lords, I'm just relying on my lord's order passed in this previous case, my lords. This was Suraj Mangar. Paragraph 19 onwards, Your Honor. Because the same facts were there in the previous case also, my lords. From para 19. 20 is the same. The last line for 20, my lords.
Yes. You say that review does not lie.
Yes, my lord. Since, my lords, they are relying on the provisions of section 75(3), which they say that that was not considered at the time of the original hearing. That was not placed before the court.
No, but if it's a legal provision, court is supposed to.
Yes, that is my case, Your Honor. If that provision is there, then there is no prejudice caused. Then they can approach, they can proceed against me. And if it is a debatable thing, then my lords knows well that this will not be under a review jurisdiction.
You say they are permitted within 3 years to.
As per section 75(3).
Can we just cite that?
Yes,
section?
yes. This is their case. They are relying on 75(3).
Yes. So under 75(3), you say that they can do it within 2 years.
No prejudice is caused.
My 3 years are over.
No, not 3 years from the date of the order.
Or a
Passed by
court.
the court.
Your friend is saying from the court. We'll just clarify that and reject the review application with the finding that under section 75(3).
75(10) also, Malay.
Yes.
75(10) gives the timeline.
75(10). What 75?
73.
Sorry,
In our 75 there is no 10.
No, I'm sorry. 73(10). I'm sorry. 7310.
Acha.
My lord, their case is that the show cause notice which has been, they have been directed to give me afresh, that has become time barred.
Yes.
No, that show cause is gone.
Yes.
Your lordship has
Gone.
given me liberty to issue afresh.
Yes.
When can I issue? Kindly see 7310.
Yes.
I can issue it. The proper officer shall issue the order under subsection 9
Right.
within 3 years from the due date of furnishing the annual return for the financial year to which tax not paid or short paid or input tax credit wrongly availed or utilized relates to within 3 years from the date of the erroneous refund.
Acha, Mr. Bandota, can you tell us this 31st of May 2024 time limit expired?
Yes.
That was during pendency of this challenge before us.
So, my lord, this
Before
has
that.
your lordship has passed the order on 28th of July 2025.
No, when was the writ petition filed? We don't.
Well, the writ petition is of
Sorry, the appeal.
no appeal is of 2025.
My lords, we preferred an appeal against the assessment order. Thereafter, we preferred a
But
writ petition.
when the time limit for issuing the notice expired on 31st of May 2024, this matter was subject to litigation.
No, my lords.
No.
We have come after appeal, my lords.
The writ petition was filed after this time. So I could not have asked for this time. The writ petition was filed after this.
But why do you say section? How does section 75(3) help them then?
It is their case.
Where any order is required to be issued in pursuance. This is not an order required to be issued. This is a notice to be issued.
It's their case. I am
73(1). My
their
notice is
grounds.
under 73(1), which I can issue 3 months before the expiry of 3 years when the amount fell due. Now, technically, it should be March 2023, but by notifications, this time is extended from time to time.
Yes.
For various different years, this time is different from
If you
1920.
grant them the liberty to file a fresh note, issue a fresh notice, then that and make it by virtue of law. If you say in accordance with law, then it's a stillborn sort of direction. We are giving a liberty which is stillborn.
Grateful.
So therefore, we'll clarify that they can do it within 1 month from this date. We'll review to that extent.
Very grateful.
Learned counsel for the review. In view of the short point involved,
The delay was can 1. Delay was can 1.
Can 1. আগেরটা যেটা দিয়েছি can 1 হতে হয়ে গেছে in view of the short point involved comma we take up the review application along with the connected application bearing can 2 of 2025. Full stop. Next para. Learned counsel appearing for the review applicant submits that although this court comma by its judgment under review dated July 28 2025 comma had granted a liberty had observed that nothing in the said judgment shall preclude the respondent authorities from issuing a fresh notice under section 73 within bracket 1 of the West Bengal Goods and Services Tax Act, 2017, and from proceeding afresh on the basis of the same, at the same time, a rider was put in that such issuance shall be upon due compliance of the relevant provisions of the said act and in accordance with law, which nullifies the said liberty ab initio. Full stop. Next para. It is contended that in terms of section 73 of the said act, the time limit for issuing a notice under section 73 within bracket 1 expired on May 31, 2024, and the time limit for raising demand expired on August 31, 2024. Full stop. As such, even on the date of passing of the judgment under review, that is July 28, 2025, the outer limit for issuance of a notice under section 73 within bracket 1 would also debar a fresh notice. Full stop. Next para. Learned counsel appearing for the respondent in the review application submits that in terms of section 75 within bracket 3 of the 2017 Act, where any order is required to be issued in pursuance of the direction of the appellate authority or appellate tribunal or a court, such order shall be issued within 2 years from the date of communication of the said direction. Full stop. Next para. Upon hearing learned counsel for the parties, we are of the opinion that section 75 within bracket 3 may not provide sufficient relief to the review applicant insofar as the moot question involved in the review application is concerned, since Subsection 3 of section 75 primarily pertains to orders and not to notices in its strictest sense. Full stop. Next para. Hence, comma, we find that although this court had granted a liberty to the respondent authorities to issue a fresh notice, comma, the said liberty was a stillborn uh, direction as a stillborn liberty, comma, in view of the notice being time barred, and particularly, comma, since we had put in a rider as to the said notice having to be in due compliance of the relevant provisions of the act and in accordance with law. Full stop. Next para. Thus, comma, we modify the judgment dated July 28, 2025, passed in MAT 53 of 2025 to the limited extent that the respondent authorities will be at liberty to issue a fresh notice under section 73 within bracket 1 of the West Bengal Goods and Services Tax Act, 2017, within a period of 1 month from this date. Full stop. Next para. RVW such and such
23 of
2025 along with Can 2 of 2025 are disposed of in the light of the above observations.
Grateful.
No address to cost.
extremely grateful, madam.
Thank you so much. বইটা ফেরত দিয়ে দাও তাহলে ট্যাগ করে দিও ডিরেকশন দিয়ে দিয়েছি ওনাকে বইটা ফেরত দিও রামেন প্লিজ টেক ইউর বুক ইজ ইয়ার্স রেগুলার লিস্ট
অনেক ম্যাটার হয়ে গেছে একটু দেখছি একবারের জন্য এগুলো কয়েকটা কটা
One, two,
Lord, in this
46.
matter, Lord, there is some mistake. Your Lordship,
no.
please to Lord dispose of the matter on 26th August. Lord, kindly come to the last paragraph, last page of the order, paragraph 56. These applications are substitution applications. This should be allowed, and Lord, the office should be directed to bring on record the names of the heirs.
Which one? Can?
Lord,
all cans.
Oh, could not be disposed of consequentially.
Lord, kindly this is.
Well, we'll modify this part of the and say that the connected applications being such and such
are allowed
and the office shall carry out the necessary amendments to the cost title. Correct. Learned senior counsel appearing for the appellants, petitioners rightly points out that in the judgment dated August 26, 2025, comma, in paragraph number 56, comma, 3 substitution applications were recorded to have been disposed of consequentially, comma, whereas those ought to have been allowed, comma, thereby directing the substitutions as sought for therein and directing the office to carry out the necessary corrections to the cost title of the writ petition accordingly. Full stop. Next para. Upon hearing learned counsel for the parties, comma, we find substance in such submission. Full stop. Accordingly, paragraph number 56 of the judgment dated August 26, 2025, passed in WPLRT 362 of 2001 is modified to the limited extent that the applications mentioned therein bearing Can 3 of 2016 bracket old number Can 7771 of 2016 bracket closed, comma, Can 4 of 2018 bracket old number Can 1146 of 2018 bracket closed, and Can 5 of 2018 bracket old number Can 1148 of 2018 bracket closed are allowed, comma, thereby directing substitution to be effected as paid for therein in the writ petition. Full stop. Next para. The office shall carry out necessary rectifications to the cost title of WPLRT 362 of 2001 accordingly.
Can
Full stop.
হবে না তো অসুবিধা নেই তো
Your Lordships, I'm from the respondent. Your Lordships has passed an order on 4/3/25.
Yes.
Which permitted the respondent who was deceased, the legal heirs of the respondent, to withdraw the security deposit. The communications were as that the department is ready to clear the amount. All formalities has been complete, but the part of the interest accrued that was silent in the order. So the department has asked whether to issue a notice to include the interest in the order, if that's possible.
Give us half a second, we'll just check.
Order notice now. Order notice now. Order notice.
It should include the interest also. Amount যদি withdraw করতে বলে থেকে with interest after deduction of the statutory charges. We'll put that in. Thank you. You are for the respondent. The legal heirs, right? Learned counsel appearing for the legal heirs of the original respondent number 1 points out that there is some confusion as to whether the interest accrued on the amount deposited by the appellant with the learned registrar general of this court, comma, which was permitted to be withdrawn by the substituted respondents, comma, would also include the interest accrued thereon. Push up next para. As a logical corollary to the order dated March 4, 2025, comma, since we permitted the amount deposited to be withdrawn, comma, it would necessarily include the interest accrued thereon as well, comma, of course, comma, after deduction of the statutory charges. Push up next para. Accordingly, the order dated March 4, 2025 is modified to the limited extent that the amount permitted to be the amount deposited with the learned registrar general of this court, comma, which was permitted to be withdrawn by the substituted respondents, comma, shall also by the heirs of the original respondent number 1, substituted heirs of the original respondent number 1, comma, shall also include the interest accrued thereon, such amount be disbursed to the said heirs, comma, subject to deduction of statutory charges.
Grateful, Your Lordship.
Thank you. Give your appearance. আর একটা জায়গায় না একটা জায়গায় সাবস্টিটিউটেড বলেছি ওটা হবে না ওটা ওই ইয়ার্স হ্যাঁ এখানে ওটা অ্যাবেট করে গেছিল হোল্ড করেছিলাম
Your Lordship, in item number 3, I'm led by Mr. Banerjee, Sudhaswata Banerjee.
Your Lordship, permit me to appear virtually today.
Yes, absolutely.
My Lord, this was in contempt, where even after the order of contempt was recorded, there was further acts of contempt. Your Lordship had issued rule that I'm given to understand that the rule has been served.
We'll just check up.
On 8th of December, Your Lordship was pleased to issue these rules.
Then we'll have to issue a warrant of arrest.
Kindly, my Lord, because even after this, he's gone ahead calling Excite, whatever he calls it.
You'll put in the requisite charges for the issuance of warrant.
Certainly, yes, my Lord, certainly.
Yes. A rule was issued vide order dated December 8, 2025 on the alleged contemner, comma, returnable on but January 16 it was returnable. Kon appearance hole daini kon to on January 16, 2026 at 2 p.m. Push up, however, comma, however, we find from the office report dated January 6, 2026, comma, that the rule was duly served on the alleged contemner through his mother. Push up next para. However, comma, we are informed that no appearance was recorded on behalf of the alleged contemner, comma, pursuant to the rule on January 16, 2026 at 2 p.m. Full stop next para. Accordingly, comma, we have no other option but to issue a warrant of arrest. Full stop. Hence, comma, a warrant of arrest do issue to ensure the personal presence of the alleged contemner on February 27, 2026 at 2 p.m. 2 p.m. when the matter shall next be listed under the appropriate heading, full stop, the necessary costs for issuance of such warrant shall be put in by the petitioner within 48 hours. Thank you.
Very great, Congress.
Thank you.
Your Lordship, instead of 48, because tomorrow is Saturday.
Within
and
48 working hours. Do it
48.
today. Ascertain from the waiver department and do it.
Deeply obliged.
Grateful, man.
Thank you.
Krishna, my lords. On the last occasion, my lords were pleased to issue a rule in this matter. Now they have purported to show cause by an
They
affidavit.
had, because we were not sitting, but they had entered their appearance. On the last. Are they present in court today, Mr. Banerjee?
My lord,
Are they present in court?
one thing, yes, all of them. On that day, they are also present.
That day they were present, we marked.
Yeah,
Note.
one thing I must pay
Yes.
submission to your lordships, my lord.
What was the nature of the contempt?
Your lordships, there was an order of status quo made by this learned city civil court.
Yes.
I came up in appeal. The appeal was dismissed. The order of status quo in favor of the plaintiff was confirmed. The property was to be used for commercial purposes, and we were to, your lordships, modify the order of status quo by permitting me ingress, egress, and in the usual course upon notice to them, etc. That was the order.
You are the defendant.
I am the defendant. I am the defendant in the suit. The plaintiff of this is a slightly unique case where the plaintiff violates the order. The appeal was dismissed. The order of status quo was modified, slightly modified by your lordships, making it very clear nature and character of the property is not to be changed, and I am to be allowed ingress and egress because I am the association, the building association.
What is the act of contempt?
Now, my lord, the acts of contempt are changing nature and character from changing it from a commercial place into a place of religious worship and marriage. That is the act of contempt. That is admitted. The photographs were there. That is admitted. The second portion is that they are not allowing me ingress, egress, as a result of which the mobile tower the telecom companies who had installed mobile towers on the roof of the building and who had to maintain and upkeep the towers, they were not given ingress, egress, and they left the premises and went away. Now, my lord, the third party rights were being created that a organization of a particular religious denomination was being allowed to use the premises, and they had set up their boards both at the entrance of the suit premises as well as the ground floor of the building in question, which has nothing to do with the plaintiff's purpose of commercial use in the lease deed, and which your lordships have also said nature and character not to be changed. Those were the primary acts of contempt. Now, my lord, even after they've used affidavits, unfortunately, my lord, this is a case of aggravated contempt. They have lied on oath. They've committed perjury on oath in
Board has been removed, as I'm told, and they have never been prevented. That is also additional. Because the parties are fighting for a long time to establish their right and other things. But so far first part is concerned regarding display of the board and performance